best possible map, because, thank you, we will look to that. Secondly, obviously, we don't want to be here until tomorrow this time. I know none of you do either. So what we're going to do for this session, which is not our typical protocol, is we're going to give you 2 minutes to open, uninterrupted. None of us will ask you anything, to give you every opportunity to set the stage. We're going to ask you questions for roughly 11 minutes. Now, in all candor, it's to constrain you more than us. So if a justice has a question at the end of the 11 minutes, the justice will ask that question. When justices no longer have questions, we'll move on, and we'll give you, but we're going to try to hold it to that 11 minutes, and we're going to give you 2 minutes to close to make sure you have the opportunity to explain to us, again, why you think your map should be chosen. And that equates to about 15 minutes per person and about 3.5 hours for oral argument. We will probably take a luncheon break in there somewhere. So that's the protocol that the court has agreed upon. I trust that it will allow you to fully articulate why you should prevail, your map should prevail before us. So with that, the first party arguing is a map on behalf of Senator Jay Costa, and that's Mr. Levine, so feel free.
Good morning, may it please the court. Clifford Levine on behalf of the Senate Democratic Caucus led by Senator Jay Costa. Let me first express my honor at being the first lawyer before you in your capacity as Supreme Court Justice, Justice Brobson.
And I thank you also, I should have mentioned that. Welcome, Justice Brobson. Go ahead.
I want to, it's interesting, I mean, the first speaker, and there are a lot of principles, so I did want to cover generally a couple of principles that really lead to the maps, and I would say that there are a number of very good maps that are being presented, and the differences and the nuances really reflect some judgment in terms of what communities of interest should be connected or how those are undertaken. But there are certain principles that I think apply, and we've been living this process for a while, and so I just wanted to briefly review those and touch upon just 3 topics almost as a sort of an opening to set the stage here for the discussion that we're going to have. What I wanted to talk about is this relationship between League of Women Voters and Holt, and what that means and how we analyze that, because there's some discussion about is having one less split somehow going to trump the vote dilution issue, and how we look at that. There's a second question that deals with how do you apply this concept of vote dilution and preventing vote dilution in terms of the application of the maps and what we look for. And then finally, obviously on behalf of the Senate Democrats, I know I speak on behalf of the Democratic House members as well. We, as you know, as reflected in the court's order yesterday, we have the LRC coming down the pike immediately behind us. We think for the same reasons, the voters should have a meaningful say in who their Congress representative is. It certainly applies equally to who their state senator and who their state representative is. So we would ask that everything be undertaken with one primary, that all the races be undertaken together. And as to that, there are some scheduling issues and maybe thoughts on how we can accelerate what might be a very tight time frame.
Mr. Levine, this is not a question on the merits, so I'm not trying to interrupt your intro, but would you introduce your co-counsel, please?
I'm sorry, my apologies. Corey Woods is my co-counsel, and Emma Shoker is with me as well. My apologies to you in particular, Mr. Woods. So let's talk about, so the first concept is what's the relationship with League of Women Voters and Holt, and there's some discussion about that. League of Women Voters is really predicated on Article 1, Section 5. It's dealing with the idea of voters having a voice. So while Holt is significant in that Holt reflected some of the traditional reapportionment criteria in terms of compactness and splits and that sort of thing, of course, that involves specifically in Article 2 criteria that's related to the state maps and the creation of the state maps by the LRC. So this court recognized that these are traditional criteria, but went a step beyond and looked at the history of Article 1, Section 5, really going back to the 1790 Constitution. and noting that it was in a significant period where there were actually battles between factions in the state in an effort to have an equal voice, to have the majority, whoever was in power, to not basically suffocate others who sought to have the chance at representation. And that's a really important concept, and for good or bad, I think we really haven't made that much progress in 1790, because we still have those issues, obviously, in terms of making sure that people have a voice, and that's really a critical component of League of Women Voters. So when we look at League of Women Voters, we're going to hear some discussion today about maps and what has one split more, one split less, but really in applying Article 1, Section 5, it's also a question about who has a voice. What does that mean, and how do we measure who has that voice? So what is this idea of vote dilution? What does that mean in terms of interpreting and reading League of Women Voters? It's really translates as equal, as this court said in League of Women Voters, it's about having an equal opportunity to translate votes into representation. So the idea you wouldn't have districts that are designed in such a way that no matter what the outcome is, you're going to, in terms of voter turnout and who's voting and what the voters are expressing, that there would be some responsiveness. And that's the key word, is responsiveness. And the example, there's no better example than the very congressional map that this court ruled was unconstitutional under Article 1, Section 5 back in 2018. And that was a map that in 2014, in 2012, 2014, 2016, produced the same result. It was a 13-5 Republican to Democratic outcome, even though those elections varied between Republican landslides and Democratic landslides. It was still going to be a 13-5 result. So that case, which of course is precedent now, but it's really a wonderful illustration of what it means to be non-responsive. So you're looking at the statewide voter turnout, and you're trying to see what kind of measurement or what kind of responsive there was. It's really no different than creating a level playing field, if you think about it in that light.
Members of the court, we have gone 2 minutes. Please continue your argument. The members of the court should feel free to interrupt with questions.
Thank you, Your Honor. So in terms of measuring it, the various parties had expert witnesses, and they were presenting testimony at the evidentiary hearing undertaken by the special master here. We had presented a MIT professor named Deb, some of the ideas and some of the ways perhaps to differentiate or criteria to look for in terms of those expert responses.
Did our opinion in 2018 in League of Women Voters level the playing field, in your view?
Absolutely. And I think we have a 9-9 congressional makeup. And again, it's not that we need balance, and I just want to make this clear, as Dr. Coey said. We're not advocating, nobody is advocating for proportional government as if we are the parliament in Great Britain. If you win 61%, you get 61% of the seats. Nobody is saying that. Responsiveness means that you could expect the outcomes to differ if there's, for instance, a Republican landslide year versus a Democratic landslide year. And in the case, Justice Todd, of the congressional map, it was not differing at all, because it was really designed in such a way not to be responsive. So the proportionality, you're going to hear people talk about proportionality. Nobody here is advocating for a Great Britain parliamentarian system. But responsiveness, if you just think about a curve, think about a curve at a 45-degree angle, and we've been dealing with lots of statisticians and math PhDs, but it's simple that if your vote is lower, you're going to capture statewide. If you have 45% of the vote statewide, you're going to capture less seats. If you have 55% of the vote, that should go up. And it should go up and down for the respective parties.
Mr. Levine, if I might, would you agree that all of the maps that we have before us essentially meet the floor requirements of League of Women Voters? The geographic equality, continuity, et cetera, et cetera.
The traditional Article 2 type of criteria.
What we refer to as the floor.
The floor, yes, I would say I generally agree with that.
Okay, so then it would be then your position that the tiebreaker is the partisan fairness analysis. Is that correct?
Yes, Your Honor, although I would actually treat it differently than a tiebreaker. I think it's actually the critical component under Article 1,
So
Section 5.
you would say it is indeed another essential requirement of the analysis. The floor that we set plus partisan fairness.
That's right. This court considered a case of the fusion voting case in 2019. I think it was whether you could be endorsed by two separate parties. And the issue was voter dilution because it was Article 1, Section 5. Now, that case did not have anything to do with compactness or splits, but it dealt with this idea of representation. And so in that sense, the critical issue in Article 1, Section 5 is the free and equal election. So, Your Honor, I would just slightly rephrase that in that I think the floor criteria really give insight into whether a fair and reasonable map is being designed. Certainly those are criteria that if you had all sorts of contrived districts, it would reflect a rejection of communities of interest. It would be indicative of the inability of certain communities to have a voice. And that's what we saw specifically in the congressional map at issue. But
I have a follow-up on Justice Donahue's questions, Mr. Levine. Considering the fact that the League of Women Voters set as one of its pristine benchmarks for fairness in assessing voter dilution, which is that you should have a map which does not divide any county, city, incorporated town, borough, township, or ward, except where necessary to ensure equality of population. How do you justify your opinion that the cracking of Pittsburgh into two separate districts meets the foundational floor of League of Women Voters?
it's an excellent question. I was going to get to it in a few minutes, but I'm happy to answer right at this point. So there is this issue of cracking and packing, which also deals with a voice, and reflecting essentially the statewide turnouts. In other words, a congressional map has statewide implications. So you're looking at that statewide implication, and if you're consistently in a situation where the voters are voting at a 50%, then the congressional makeup, just like the current makeup, is 9-9. So the question is, when is it, what is cracking and packing? So packing is when you're putting people in a certain district, and that is not always a positive thing, and because sometimes it could, there are many situations where you might have certain communities that have a voice, and by putting them together in one, they could have influenced 3 seats by their population, and instead they're only dealing with 1 seat. Cracking is a situation where you might have a town, like say in Allentown, or Bethlehem, a town, I'm thinking of something 75, 80,000 people, and you split it in 4 different parts, and you create like a pizza pie where they just have a little point. So the people in Allentown in the northeast corner and the southeast corner, they really don't have an influence in the seat. So as to your question about Pittsburgh, there was testimony, Dr. Naughton, or Keith Naughton testified about giving Pittsburgh a voice. But Pittsburgh has a voice, and it's just interesting understanding the geographic layout of Allegheny County. Number one, Pittsburgh has the rivers, obviously. It has the diversity. It has, 83 or 90 some neighborhoods. And the southwest portion of Pittsburgh may be very different than the northeast portion of Pittsburgh.
I've got to interrupt you there, Mr. Levine, just because I think what we're talking about is a community of interest. And I read your analysis of Pittsburgh being in different communities, different sides of the rivers, but since at least 1980, it has not been divided. The population of Pittsburgh neatly fits within one congressional district. It's not, in my understanding, of absolutely necessary, which Justice Mundy asked about necessary, I think it even goes beyond that. Was it absolutely necessary to split Pittsburgh into 2 districts? So that was my concern, that it is a community of interest.
Yeah, and I guess to clarify is, I read your brief and I understand about communities of interest, and I think the court understands the term of cracking and packing, but when we have all these maps that are trying to adhere to the League of Women Voters benchmarks, and we have ones that have less municipal cracks or splits that keep Pittsburgh as a whole, it just drives the question to us.
Well, and that's fair, but I would suggest that because there's also this Article 1, Section 5 analysis of giving a voice and having people have that opportunity to speak. What's interesting in Pittsburgh, for instance, with a municipality of 300,000 people, it's essentially 8 times larger than the next size municipality. No, but my only point with that, theoretically, if you split it in half along the river, if you split it in half, you'd have 150,000 people, and the testimony of Controller Lamb was there are actually communities of interest that are more closely aligned. And so to answer your question, Judge Mundy, there would be nothing wrong with having Pittsburgh together. We're not going to advocate that, but the question would be if the map then, we've had one of the other amicus here said that, well, taking part of Pittsburgh and the South Hills and bringing it down to Washington County wouldn't be appropriate. And so the question is what you end up with the 2 maps. So it very well may be that by not splitting Pittsburgh, you come up with a district that really is kind of not any type of communities of interest. So historically, I know some of the justices will recall the congressional seat that Rick Santorum had, for instance, was a ring around the entire city.
Now you're going back to the bad old days.
The bad old.
So to speak. I mean, focusing on the post-League of Women Voters world. On the one hand, your map is one of the least, if not tied for the least, preserving of the cores of the current League of Women Voters map. And given that, why would it serve the values articulated in League of Women Voters to split a city that doesn't need to be split? And remember, you have 4 Pittsburgh area justices up here to whom you're trying to sell a split between Pittsburgh on the north side of the Mon and Pittsburgh on the south side of the Mon.
And further, why it is absolutely necessary
Yeah.
to split
So
Pittsburgh.
we've dove there. Your 11 minutes of argument are done. Please answer Justice Weck's question, and we'll see if there are any other questions, and we'll move to your conclusions.
Well, I think the answer is that under Article 1, Section 5, I think that there can be some considerations to ensure that there's a voice and that there's communities that are reflective. And I think, to make the old Pittsburgh joke, people don't cross rivers. So the answer to your question, Justice Weck, might be that the alignment of certain communities, that even though it's a city, the alignment of communities of interest is closer from the South Hills to the
Well,
North Shore.
ironically, Controller Lamb, with whom I was a fellow row officer back when I was also a politician, he crosses that river every single day, twice a day. Mount Washington downtown.
Well, I mean, he lives it, but I think it's a reasonable. I don't know that you have to say that you could never find a situation under Article 1 to see that a split would be appropriate to give a voice. But again, I don't know. I'm not going to say that it's absolutely necessary. I can't say that, but I do think it's a criteria because I think under Article 1, Section 5, as distinct from perhaps the LRC situation under the specific control of Article 2, Section 16. I think there's some flexibility.
Justice Donahue has a question, and then we'll, absent further, we'll move to sum up.
It might be a yes or no answer, maybe not. Does keeping political subdivisions whole trump the compactness requirement?
There's no clarity on that. I would say not necessarily, and I think there's some judgment here. And again, as Chief Justice noted, you're sitting in your original jurisdiction, and I think you have flexibility. There is no, in terms of these floor criteria,
Because you're splitting Pittsburgh, and I wouldn't say cracking it, but I would say splitting Pittsburgh creates a more compact.
Well, and I think there's some advantage to that.
That's why I'm asking you the question.
Yeah, so I would just simply say that there's no priority necessarily, that you're looking at it, you're considering various issues. Just quickly before my time expires, I do want to just address,
Well, I'm going to give you 2 minutes as of now to tell us the most important thing you...
essentially an 8 to 1 map, which really is fair and reflects the state. One of the arguments that you often hear is that the geography of Pennsylvania is such that this is impossible to do. And that's just not a valid rationale under Article 1, Section 5. And the reason that the geography, I'll make an analogy, we're a hilly state, and yet somehow every high school football stadium in Pennsylvania can be on a level playing field. There's ways that you can create and look at a level playing field, and that is done, as the experts have testified. You can put in the floor criteria, as Justice Donahue alluded to it. You can have the floor criteria, and you can spit out 50,000 maps in an hour. And the 50,000 maps in an hour then all meet those floor criteria, but then you can measure partisan. And when you measure the partisan, you actually have a bell curve. And so there are certain that'll be extremely Democratic, certain ones that spit out as extremely Republican, and there's a whole bunch in the middle that you could come out with your 8 to 1 or 9 to 9s or whatever it is. And under League of Women Voters, that's an appropriate exercise. And so the notion that we're all standing here helpless when we look at 50,000 maps and 20,000 of them might create, or 15,000 of them might create a fair map, should reject the notion when people tell you that there's simply the partisan role here. The final thing.
I just have one question. I'm sorry, Chief Justice, if I'm throwing your time off, but I have a difficult following your discussion about political geography, and just from a common sense standpoint, and from the perspective of having the opportunity to run statewide across Pennsylvania, there are areas in the state, for example, Pittsburgh, Philadelphia, Erie, Center County, just for examples that are weighted heavily Democratic. And as everybody, I thought, commonly understood, the T of Pennsylvania is predominantly Republican. Doesn't that type of scenario contradict what you just said with regard to the political geography of Pennsylvania?
No, respectfully. Because I would agree with you that it would be very hard to create a Democratic-leaning seat in north central Pennsylvania. It would be very hard to create a Republican-leaning seat within the city limits of Philadelphia. At a statewide level, this court did it in 2018. It did it successfully, and it's a wonderful thing for our democracy that there's some responsiveness there. So we know it could be done 4 years ago. Many of these maps do have that sort of parity, and when you're outside of the extreme, when you're maybe outside of the city of Philadelphia or outside of the north central, then there's opportunities to create districts that have respondent communities. And so one other example, for instance, there are smaller communities, but they have metropolitan areas, and they identify it as one. Or you could split, again, you could crack or not. The last thing I would just like to cover, as my time is close to expiring, the notion of what is partisan and how we measure that, and what does that mean, and why is it that the map that was recommended by the special master, which is kind of ironic, it was the House Republican map that was recommended, and despite a geographic leaning, as they have advocated, they are asserting that it's actually a 9 to 8 Democratic map. And again, dating myself, Justice Weck, but in the spirit of Columbo, who might scratch his head and wonder, how is it that they had a 9 to 8 map with the circumstances? And the reason is, as Dr. Coey pointed out, it really depends on your baseline. And he pointed out that the baseline of that map assumes a 54% Democratic turnout statewide. So in other words, in a landslide year, you can create a baseline that is very deceptive. And when you go back down to a 50% year, that would become a very heavily Republican seat, or less, and it goes down. And again, that goes to the core of responsiveness. So one of the questions as we're talking today, what's the baseline? What are the elections that you use? Our maps are fair in the sense Dr. Coey prepared and indicated it was actually, the averages came out to a 41% Republican average over a number of elections, and the partisan makeup of there indicated a responsiveness. So it's not just at 50%. You want to see that if the vote's up to 54%, there's a change, and down to 46%.
What was his projection in terms of Democratic turnout? You said 41% Republican.
No. What he said is he said the baseline of these averages was that statewide it'd be 51% Republican turnout, slightly Republican in terms of the sampling that he had used, slightly, but it's essentially a 50-50, and that's what they said.
We have one last question.
My pleasure.
Are you and your clients generally in accord with the analysis that was performed by Dr. DeFord, where he did an analysis of all of the maps using the same baseline information?
Yes, we're
Okay, thank you.
doing that. And then just if I could make
10 seconds. please.
yeah, the last point is we think we should run together for the same reasons, as I said, the voters should have the say also in the state Senate. We should run together. It's an aggressive map or aggressive schedule that's being proposed. There are situations that I think could cut down time. I think Justice Brobson, his experience of running election court on the Commonwealth Court, would know there maybe are improvements, and we'd be happy to have some sort of bipartisan effort to try to cut down the schedule and work
Welcome
together.
any bipartisanship. Thank you very much. Next argument will be presented on behalf of Congressman Reschenthaler by Mr. Haverstick. We've not been outstandingly successful in maintaining our own discipline, but notwithstanding, we'll try again. 2 minutes.
Thank you, Your Honors. May it please the Court. My name is Matt Haverstick, and I represent the denominated Congressional interveners. I'll add there are a couple of non-Congress men and women in that group. Your Honors, when this Court concentrates on the neutral, constitutionally articulated principles that you used in the League of Women Voters, and when this Court considers neutrally and naturally the geography of Pennsylvania, and specifically where people in Pennsylvania have chosen to live, where they have put themselves, something starts to happen with all of the maps that are in this case. They start to sort themselves. And what you find when you consider these principles, these neutral principles, is that the maps start to group themselves into those that are genuinely creating communities of interest in the broadest sense, not just, as I think Dr. Naughton called them, red and blue pegs or widgets, but in terms of communities of people who have lots of different thoughts and hopes and dreams and likes and dislikes and like certain sports teams and watch TV in certain markets. There are maps that are very good at that. And then there are maps that are not so good because they're trying to do something else other than adhere to neutral principles and other than match, again, the political geography of the Commonwealth. I submit to the Court that the Reschenthaler maps 1 and 2 are in that order of maps that are capturing in a very real, organic, natural way where people live and what they think about and what they care about. That is the communities of interest that we all care so much about and frankly underlie and are the point of the application of the Article 2, Section 16 principles. And I'd urge the Court, for that reason, to accept one of those maps as the map to be used for the next election cycle and beyond.
Let's open it for questions.
Counsel, maybe you could, and I'm trying to keep all my maps in my mind.
Me too.
Not easy. But I know you know your maps. Do the plans that your clients put before this Court split Washington County?
I believe that there is a Washington County split, yes.
Okay, now let me ask you about that. I'm interested in this split analysis.
Me too.
Is there a priority that the fewer splits should take place at the county level because that is the predominant political subdivision, so to speak, in Pennsylvania.
I would argue yes, Your Honor, and I think one of the reasons our map is so good in that score is ours is the best in terms of county splits among all the maps at 13. That's the fewest county splits. And
does that take into account that Chester County isthmus?
yeah, that the Birmingham Township thing, we don't have, that isn't an issue in our map. It is an issue, I think, in the Carter map.
Okay, let me get back to this splitting Washington County then. If we're in agreement that, and I think I might agree with you, I don't know, because we've never said it, but if the predominant analysis should be on the largest political subdivision, i.e. counties, then why wouldn't we be more concerned about splitting Washington County when it need not be split than splitting the city of Pittsburgh?
Well, it's an excellent question, Your Honor. I think the answer is twofold. First, Washington County, they are going to be, we concede, everybody concedes, that when you're going from 18 seats to 17 seats, you're going to have to split. Frankly, it's remarkable that we managed, I think, to split less than the last map, considering as much less as we did in the last map. We're going to have to split some counties. I think the trick is splitting jurisdictions, whether they be counties or large cities, for reasons that are permissible. And a permissible reason to split a county, for instance, may be that that's just how the math works in that part of the state. Contrast that with the split of Pittsburgh, which there was no record evidence presented that the split of Pittsburgh was necessary for any reason other than partisan politics.
There is no evidence that it was done for partisan politics. That was an assumption, but I mean, there was no evidence of that, as I understand.
I know, well, said another way, when asked, no one could justify a reason for splitting Pittsburgh that wasn't based on creating two seats. And I do think there's record evidence.
If I can help you, I think you're arguing is that there's an inference of gerrymandering there.
I recall, Your Honor, that there may have been some testimony that someone said specifically we're splitting Pittsburgh to create two competitive Democratic seats in the Southwest. Look,
May I ask you, this is a follow-up to Justice Donahue, and I think the issue of the city of Pittsburgh split's already predominating here. Allegheny County has more people than a congressional district. Therefore, Allegheny County has to be split under a one-person, one-vote theory. If that's so, why isn't the split of the city along the river, if you will, as palatable as lopping off the North Hills, which is all Republican, or the South Mon Valley, which is all Democrats? And again, we all come from Pittsburgh, so we at least generally understand it.
and you have me at a disadvantage because I come from Lancaster. But yeah, I think the answer is, again, when you're trying to group communities of interest, the way at least the Reschenthaler map cleaves off a little bit of Allegheny County, but predominantly keeps Pittsburgh with the bulk of Allegheny County, is a way that at least Dr. Naughton testified, makes sense for those communities. There's never going to be perfection in any of the splits that we do, but I think what's important is the consideration of one, especially for splits, that they are truly minimal. And the bigger the jurisdiction, I think the more explanation you need to give if you split it. And as to explanations, I think you should look at where the splits occur. And if you split a county, for instance, we split Monroe, but look at where we split Monroe. Where we split Monroe groups East Stroudsburg University in a district that cuts down and captures other major universities in the eastern, northeastern part of the state, like Lehigh and Lafayette. And then the other part of Monroe is more appropriately in the Poconos. Dauphins, a split that in our map is very purposeful. It's right around like where the Red Rabbit is. And I mean, I go into Penn State games as a kid from Lancaster. When I got, even as a little kid, when we started going up around Duncannon and going towards State College, I sort of felt like I was in a different part of the state when we got by the Red Rabbit and where the Sheets is. Now that big Sheets and the big Rudders is. I mean, the splits that the Reschenthaler maps make are ones that track geography, that track primarily geography, but sometimes political borders too, even when they're splitting counties.
Mr. Haberstroh, oh, I'm sorry, were you finished with that sentence?
No, I'm done.
Okay. In follow-up to Justice Donahue's question about, do we put more emphasis on splitting a county than splitting a city? We have different municipalities, different levels of organized cities, counties, districts, municipalities that we're looking at. But we've never, in League of Women Voters or any other place that I'm aware of, we have never said there's a hierarchy in the types, that a county split is better or worse than a split of a big city like Pittsburgh.
I think that's fair, Your Honor, but
It's more of a common sense analysis.
well, but I think it's more than just a common sense analysis. I think in Holt 1, there's some commentary, and now granted, it wasn't a holding, but there's start to be teased out the idea that because counties historically were so and are so important to how the Commonwealth forms and governs. I mean, when you think about what a county does, it's the primary recipient of federal money for a locale. I mean, that's where federal money usually goes, and it gets dispersed out to communities. So there's beyond just a level of sense. I mean, I think that reading between the lines, this court has given credence to the idea that there is a hierarchy. And I would argue that there is, even though, granted, it is not expressed.
And we have the opportunity to clarify that in this upcoming opinion.
Yes. And to the extent, look, I think that consideration of splits is critically important, because I think it is a way, forgetting second tier or even tertiary ways of evaluating all of the maps that are before the court. I think the fidelity here has to be given to the constitutional principles, because they, one, are metrics that we can look at, and they're numbers, and we can match them up, and we can say numerically you have less splits, which the Reschenthaler maps do in terms of counties and municipalities.
Mr. Haberstroh, may I ask you, as I suspect, although I have a timer in back, your time is beginning to draw nigh. Mr. Levine argued one of the more naughty theoretical questions pervading this area, which is emphasized that he is not arguing for proportionality as the British parliament system would have it. He is arguing for responsiveness, whatever that means, and he is arguing, I think, that responsiveness would justify a consideration of partisan fairness. And I do think that League of Women Voters, which I thought Justice Todd wrote masterfully, elevates partisan fairness under the fair and equal election clause of the Pennsylvania Constitution and the theory that we don't dilute one person's votes. So I just wanted your view, as again, I'm trying to tease out in my mind where partisan fairness sits, where responsiveness sits, where partiality sits.
Well, in correctly answering the question, Chief Justice, you even yourself noted when you're talking about something like responsiveness, I think you did a hand gesture. What does that mean? I know cases like Veith and Rucho aren't controlling on this court, but they have conversations about how ephemeral these concepts are of fairness, of proportionality, of responsiveness, and how hard they are for an organization and like a body like a court to get its arms around and articulate a rule. And I think that's important to understand what these tools actually are meant to do. I believe, and I think this is what this court did in League of Women Voters, is use partisan fairness metrics as a way of determining whether a map that came through the political process and admittedly did not match standard metrics for what we think a neutral constitutional map should look like. This court was then charged to figure out, well, why does it look like that? These numbers don't look right. How can we tell if this is an unfair map or a fair map in almost a binary way? So I think the appropriate use of concepts like partisan fairness, like responsiveness, are, as one of my colleagues said to me earlier this morning, they're gut checks.
May I follow up briefly on that?
Yes, Your Honor.
It seems to me, and I'd like you to react to this, that there is a principal distinction as between our enterprise in 2018 in League of Women Voters and now, at least on one dimension, as follows: that in League of Women Voters, we were dealing, with respect to the partisan fairness metric, if you will, with a track record of an entrenched gerrymander across at least 3 elections cycles. Here it's a projection, it's a heuristic, we don't have experience on partisan fairness. We're trying to project across all these metrics without the benefit we had in League of Women Voters of at least 3 election cycles of what can fairly be called entrenchment. Can you react to that? Disagree? Agree?
Well, no, look, you're right. We don't, and that's why these metrics that we're talking about are good gut checks. They're not first-order constitutional concerns for a reason, because they're inherently unstable. I mean, they're great, you can tell whether they worked or not when you look backwards, but looking forwards, especially as you project out in years, they become less and less reliable. I think their highest utility for the court today, and you're absolutely right, you were in a totally different posture than you were in 2018. In 2018, you were taking a map that you acknowledge, or I think the court quite bluntly said was too much, and you made one adhering to neutral constitutional principles. That's not what you're doing today. You are taking a bunch of maps that everyone acknowledges, I think, on this court, and most of the parties acknowledge, are all within the range of constitutionality, and you're trying to figure out which one of these do we use. So it's
Mr. Havister, can I apologize for interrupting, but I also want to commend whoever in my staff won the pool about how long it would take for me to ask my first question.
is it your first? Oh, wow. Okay.
So yeah, it's my first question. So we'll see how
The answer to a trivia question.
we'll see how this goes. But you're getting to a point which from a judge who read the League of Women Voters opinion, had something to do with the trial aspect of it. I read that decision a little bit differently than some of the parties are arguing. League of Women Voters was a situation where there's an alleged unconstitutional gerrymander, a map that the natural order of things, I think you mentioned political geography, would have dictated X. And maybe X was a plus something in favor of Republicans. Went to an inordinate direction further to be plus something more to Republicans. And the challenge before this court was, how do we determine whether that map has exceeded the bounds of partisanship? And the court said, well, we're going to start with whether a map satisfies the neutral criteria. And this court determined that that map did not satisfy the neutral criteria. It didn't go any farther because it didn't have to go any farther. But what I think Justice Todd astutely wrote in the opinion was, this court recognizes the possibility that in the future, a map could still exceed the bounds of partisan fairness, yet satisfy the floor criteria. And that seems to be the window that was left open in League of Women Voters. Are we dealing with that here? Do any of these maps exceed the bounds of partisan fairness? Has anybody argued that?
No, and to the contrary, I think all the authors acknowledge what you were dealing with in League of Women Voters, which I think the chief called an excessive partisan gerrymander. And
well,
I think
my question is more specific. Is the window that was left open by this court, was that intended to say that the free and equal election clause demands nonpartisan, everybody has a 50% shot at winning, or does it simply say there could be a situation in the future where a map is selected that is still excessively partisan and a gerrymander, but satisfies the floor. And if that happens, then we need to go to these other metrics and see what's going on.
Well, look, not to put words in Justice Todd's mouth, but I think that's the correct application of what could happen. I mean, what I understood that piece of the opinion to mean, Your Honor, is that given the prevalence of supercomputers, ENIAC and Watson, or whatever they call it now, that you could come up with a map that minimally meets what at least League of Women Voters articulated were the constitutional standards, and yet may have been motivated by some excessive, unconstitutional, partisan malice, bias. I mean, I don't know what you call it, but it left open the possibility of that.
Well,
but,
not addressing it in the opinion.
Right, but that's clearly not what we're dealing with here. And I think you're right, those metrics, to the extent that someday that happened, the legislature, for instance, drafts a map like that, you'd be back in the same position you were in League of Women Voters, and that's where those second-order factors come in, because you may be able, what you did in League of Women Voters, I think, is, again, you took a map that was brought before you that didn't match up on the neutral factors, and you had to understand why. Did it happen sort of naturally and therefore permissibly, or was it done deliberately in an unlawful way? And that's where the partisan metrics came in, to help this court determine, in our opinion, the map was drawn in an unlawful way because it was excessively
May
partisan.
I interrupt you? I just want to make sure I understand your answer to Justice Brobson. What I thought I heard was that your studied view was none of the maps in front of us went so far in partisan fairness as to be invalidated.
I do not believe so. I think what I will say, though, but let me be more precise. I think there are maps that are what I would consider not ones drawn in a state of nature. That is, they are not reflective of the partisan reality of Pennsylvania. And I think the explanation for why those maps do not match what happens when, for instance, Dr. Dilution testified she ran 100,000 simulations that were done with neutral applicability of the neutral constitutional principles only, and they came out with a predominant Republican tilt, again, just based on where people decided they wanted to live in the Commonwealth.
Counsel, interesting you should say that. Can you share with me? I'm from the east side of the state. The map you have submitted puts 3 incumbent Democrats in competitive races. In a particular, as we said, political geography, we know Philadelphia and our surrounding counties lean Democrat. Why would you do that if this is a community of interest that's so...
Mr. Haversack, please answer that question fully, but try to finish up. We've long expended your time, but certainly we all want our questions answered. Do you understand Justice Dockery's question?
I do. Your Honor, I would say that they're not quite in the Philadelphia region. One is a pair of a Republican and Democratic incumbent.
It would be Cartwright up in
Cartwright
Hanlon,
and Houlihan.
Right.
And Your Honor, I think the answer to that is when you draw maps, when you're losing a congressional seat and you're drawing maps that adhere to neutral principles, some of those matchups happen. I don't believe it was by design. I think that it was something that happened because we split only 13 counties and we split only 16 municipalities.
Permit me to follow that up with, this court usually gets involved in redistricting matters only with regard to constitutionality issues. We don't have that here. So we are now presented with what Justice Todd foreshadowed in League of Women. So for your clients, from your client's perspective, what do you believe should be the priority for us to consider when we're looking at these various maps that everyone has conceded is not partisan gerrymandered?
Adherence to the constitutional requirements with an emphasis on splits, with the gut check at the end of whether your chosen map badly flunks on some sort of partisan metric. And I would submit that none of them badly flunk on the numbers. I would submit that some of them are moving people of political parties around to make their maps look better.
If we all are in agreement that the 2018 map was fair and created these neutral standards, share with us, if that's the model, what percentage of people remain in the 2018 districts under your new map?
I think, Your Honor, it's around 76%. I urge caution, though, in reliance on a functionality like least change. I actually commend to this court for discussion of a lot of these principles, the Wisconsin versus, the Johnson versus Wisconsin Board of Elections case, because it talks about least change. Least change may be appropriate when you're actually keeping the same number of seats. It's imperfect when you're losing a seat, and in fact, it was addressed, I believe, in Holt 2, and Holt 2 cautioned this court to watch out, because that, and by the way, the counsel for the Carter folks made this argument in Wisconsin. Watch out with least change, because what least change can do is lock in some things that maybe don't reflect the census numbers that you have today.
But it's fair to say there are other jurisdictions in the United States where the courts have utilized least change as the standard in reapportionment maps. I believe there was in Wisconsin. I'm drawing a blank now.
Here's what happens when you...
We need to conclude this. Certainly answer Justice Doctor's question, but also try to...
Here's what happens when you prioritize least change, which, by the way, is not a constitutional requirement and is a second-tier order, and so you have to undo what you did in League of Women Voters if you prioritize it.
Never been articulated by us as a standard to date.
No. When you use least change in Pennsylvania and it loses a congressional seat, it distorts what the congressional maps look like. And they may be able to say numerically they are within a compact range, but look at the Carter district that runs from Armstrong County all the way up to Tioga. I mean, if you drove, I think it probably takes like 4 hours to drive from Katanning up to Tioga. That's a mammoth district. It sprawls. Look at the Carter district.
It's not geography, it's people.
But
I am sure that I have more people in my block in South Philadelphia than that 4-hour drive through those counties.
But then compare, Your Honor, Reschenthaler's 1 and 2 and the district that captures that part of the state, and how much more compact it is, and how much more of a cohesive unit it is. I mean, is it cohesive to say that people who live in Armstrong County, close to the Pittsburgh suburbs, have a community of interest with people who live in Tioga?
Well, I'm looking at them you have the same Armstrong to Tioga line in your map as Carter does.
I don't think we do. I think, Your Honor, when you look at the dimensions of that district, look at the dimensions of Reschenthaler 1 and that Carter, and how big that district is and how much bigger that district is. That's what happens when you adhere to least change and you lose a seat. They get distorted. I mean, it's too big. And the Carter district that runs from practically, what goes from almost Hershey Park all the way up to Bradford. That's a huge geographic district.
And Carter pits incumbents together, too.
Pardon me?
Carter pits incumbents.
It does. It does. Least change may have its place, Your Honor, just not in a situation where you're not using the same census numbers, and certainly not in a situation where you lose a congressional seat. And if it did, at least change would suggest that they would be able to split less municipalities in the Carter map than you did in 2018, and I think they split more.
Mr. Haversteck, before you sit down, would you be kind enough to introduce your co-counsel?
Thank you, Your Honor. My co-counsel is Shoheen Vance, and he's seated back. No, he's seated right there.
I think it's important that we acknowledge all the attorneys that, I know you have many more attorneys who aren't with you at the bar, but we like to acknowledge all the attorneys who appear and who have worked hard on the cases.
Thank you, Your Honor. It is important, and it was remiss of me not to do it. This is, for everyone I know in the room, a group effort. These are very hard issues. They're very complicated.
Thank you very much. Do you want to say something in closing?
Briefly, Your Honor.
Very briefly.
And I think I've made the points I want to make about what Pennsylvania looks like in a state of nature. I commend the court to Dr. Dilution's testimony and expert report, and some of the other experts have said the same thing. Pennsylvania is not a homogeneous state in terms of the red and blue widgets, and it's certainly not a homogeneous state in what matters to people in different parts of the state, even if they may happen to be the same political party. On the issue of, call it proportionality, call it responsiveness, call it partisan fairness, I believe these are all code words for another way of saying gerrymandering. And I, again, commend Dr. Dilution for being honest about what she thought partisan fairness meant, because in her testimony, fairness did not equal neutrality. Fairness meant something else. And she specifically said that in her map for the governor, she was moving people around to overcome Pennsylvania's natural geographic tendencies, that she was doing that to temper those tendencies. I believe whenever you move voters to disadvantage one political party or advantage another, for whatever reason, noble, righteous, it seems fair, nonetheless, that's gerrymandering. And if that's going to happen in any capacity, that should be left for the legislature. And finally, on that point, Your Honors, I recommend this court, I'm sure it has, consider the articulation of the court's role in this particular instance as discussed by the Wisconsin Supreme Court in the Johnson case. I think that case very aptly captures the proper role of the court here, when it is not seeking to invalidate a legislative map, but instead it is trying to choose among a bunch of maps that admittedly are all within a constitutional range. Of those maps, which one adheres best to the state constitution? Not that does something else that may be desirable but is better for the General Assembly to do. Which one is effectively the most constitutional? I'd submit to you that in our case, it's either the Reschenthalers because of the numeric amount of splits and where those splits are.
I think we understand your position.
Thank you, Your Honors.
Well argued.
Thank you.
Thank you.
Ms. Carol Ann Carter, represented by Matthew Gordon. Attorney Gordon.
Good morning, Your Honors, and may it please the Court. I'd like to begin by introducing my co-counsel,
Excellent.
Mr. Mike McDonald.
Welcome.
And with that, I feel like I can now go forward.
And what was the name again?
My name is, I apologize, I focus so much on my co-counsel, I forgot.
I got you off track there, didn't I?
Thank you, Justice Donahue. Matthew Gordon, on behalf of the Carter petitioners, along with Mike McDonald. Your Honors, 4 years ago, this court and League of Women Voters adopted a map guided by the Free and Equal Elections Clause and its overarching objective of preventing vote dilution by mandating that the power of the vote be equalized to the greatest degree possible. Those are the words of this court in the League of Women Voters case. The map that this court chose reflected this court's considered judgment about how best to put those constitutional principles into effect. It's a good map, it's a fair map, it's produced fair outcomes. No party to this proceeding, none of the many, many parties or amici here have said anything differently about that map. Now this court has to choose a map again. And it again is charged with deciding how to best effectuate those ideals and that mandate. And the question is where to even begin. And the Carter petitioners suggest that you begin where you left off in 2018. That's what the Carter petitioners did in creating the map that has been put forward before this court. Dr. Roden picked up the pen where you set it down in 2018. And the Carter map doesn't just begin where you left off. The Carter map also sought to improve on the 2018 map on the traditional redistricting criteria, and it does so. The Carter map also excels on the partisan fairness criteria. There are many different criteria that have been floated by the metrics. The Carter map is unsurpassed on partisan fairness. And the Carter map undisputedly, and this is maybe one of the few points where there is no dispute, the Carter map undisputedly stands out as the one that most honors this court's judgment in 2018 by changing as little as possible from the 2018 map.
Could I stop? Oh, is he still in his 2-minute intro?
I do not know. We will assume he is not.
Okay.
Go right ahead.
I did have a question about that. We've started to hear, and we're going to hear more, I know, about lease change. And that is one of the touted benefits of the Carter map, that it adheres closely to our map in 2018. And it, maybe of all the maps submitted, has the least change from our existing map. Now, everybody knows we can't use the 2018 map anymore because now we have 17 districts, not 18 districts. We obviously need a new map, and it's admirable, I think, to draw a map that is very close to what the 2018 map did, because it obviously, you know, has proven to be a fair map. My concern, though, is lease change from the existing map has never been, to my knowledge, an articulated standard that our court has made, certainly not in League of Women Voters, and maybe you could educate me if there are other places where we've said that we would adopt lease change, but all of these parties who have submitted maps, to my knowledge, have not regarded that as one of our required standards. So I'd just like to hear your opinion on how relevant lease standard is and whether we really can consider it in this case.
In League of Women Voters, this court did not use the phrase lease change. This court did talk about the preservation of districts, of the core of districts.
And we didn't have a constitutional map to compare it to.
That is correct.
To analyze lease change, because we were looking at a gerrymandered map and creating a new map.
That's an important distinction.
It
I
is.
agree with you, Justice Todd, that lease change didn't come to the fore in League of Women Voters because the circumstances there were different. But this court did acknowledge that preservation of districts is a historical redistricting criteria. This court acknowledged that in Mello as well, where I think the court said the comfortable familiarity of existing districts. So this court has on at least 2 occasions talked about the importance of preservations of districts, which is the same idea as lease change.
But isn't it also key to, on Justice Todd's point, isn't it also key to recognize the principled difference that I ventured to Mr. Haverstick, that our enterprise in 2018 was to relate to a gerrymandered map and create something anew based upon past performance, whereas here we're looking at making necessary change to a fair map that we created and against which we have no performance metrics.
Well, we do have performance metrics for the map that's been in place for the last 2 elections, and
I mean, not the 3 cycles.
Sure. So there are performance metrics on how this court's 2018 map has performed in the real world. And I don't think, again, any party has contended that the map has not performed well, has not performed fairly in the last couple of elections.
A 9/9 congressional election is probably pretty good evidence that it was a fair map.
I agree with that. So we do have...
Misspoke. I'm so sorry. I totally misspoke. I meant obviously we have no performance metrics for the districts that any of you have proposed to us.
The future districts.
We don't have...
And therefore, there's a virtue in using the core.
I agree completely. There is additional virtue in using the core, and I think that's one of the things that the lease change approach does when you're starting with a good, fair map. is it serves as an additional bulwark, additional guardian against undue bias sneaking into maps, because it's a way to check how, it's a way to adhere to lines that were drawn and that have performed fairly. Of course, there have to be changes.
Mr.
And there
Gordon,
are,
I'm sorry. Yeah, and you may have been segueing exactly what I was going to ask you. And I'm following up on Justice what Mr. Haverstick argued, and you heard him, that least change doesn't work because we have one less district, one less congressperson. And the oldest axiom in the law is change the facts, change the results. So we have completely different facts here because of the loss of a congressional district. Why doesn't that make the potential of trying to follow the old map really problematic?
well, I have two responses, Chief Justice Barrow. One is that we're not saying no change. It's not no change. It acknowledges there have to be changes, right? And this is an additional virtue of the Carter map, is that Dr. Roden, alone among map makers, put in his report and testified before the special master about the changes he made and why he made those changes. So this court can analyze whether or not, what the rationale were for making those changes and why they were made. So yes, of course there have to be some changes, but in every redistricting case, there are changes. Even where there's no change in the number of districts, there's changes, there are population shifts, district lines have to be redrawn. It's a difference of degree, not of kind, between the redistricting situation where you have shifts among the districts and district lines have to be redrawn, and one where you lose a district. The least change principle applies in both cases, both because, again, and I want to be very clear here about the argument that we're making. We're not arguing that least change is of constitutional magnitude or that it should be elevated above the traditional redistricting criteria. We're not arguing that least change is the proper approach in every case. Certainly, as Justice Todd noted, it would not have been the proper approach in League of Women Voters, given the template that you were working for. What we are arguing is that in this case, it is a key factor and it is a dispositive factor, and it's one that helps cut through the unwieldy number of other factors that you have. You've been presented.
I'm sorry, may I,
Yeah.
counsel?
Yes.
I don't believe this court is asking let me rephrase that. You're not asking this court to consider least change as a constitutional concerned factor.
That's right.
But you are, I'm sorry,
Right.
go ahead.
Now, it's fair to say that none of us on this bench are in the map-making business. That is for the General Assembly. We are unwillingly forced to be here. So let's make that clear. The 2018 map was a judicially created map. The majority of the historical factors that one considers in a reapportionment or redistricting, such as pairing incumbencies, community of interest, that really is an issue best decided policy-wise by the General Assembly. What I'm gathering is that you're saying, since this is a judicially created map and our guidepost is 2018 map, to avoid the appearance of our political imprint on any map, the least changed from the initial judicially created map is the best way to go. Do I understand you?
That's part of it, Your Honor. Yes, that's part of my argument. That least change has a number of virtues, that being one of the virtues.
So is it just that you're asking us to make it a judicial standard possibly to be considered when we're forced between many maps, if we're ever forced into this position again?
I'm not suggesting that this court need to change the law at all. I'm saying that in this particular circumstance, this court, as I mentioned before, has previously recognized the value of preservation of districts. In this particular circumstance, where the 4 floor criteria don't do the work of separating out the maps here, this court has to look to something else. And least change is one of the other factors that this court should look to, along with partisan fairness. And it's one where the Carter map stands out above the rest.
It does. I agree with you on that, Mr. Gordon. And I think that the least change standard is admirable, and I'd be willing to embrace it. My problem is that unless we can say clearly that our discussion of preservation of districts and the importance thereof in League of Women Voters led naturally to this conclusion that we're going to pick a map based on, at least in part, the criteria of least change. Unless we can say that, I don't see how, other than prospectively, we can adopt least change as a standard or a criteria over and above our constitutional metrics that we've already identified, when all of the map makers and attorneys before us did not have some indication from the court that that would be a criteria or a standard. That's my problem. Not that it's not a good thing. I think it's admirable and I like it. But my concern is, other than adopting it prospectively, how do we fairly do that in this case?
Sure, and I think, again, and not to beat a dead horse, but this court has talked about preservation of districts
Right,
in
we
at
have.
least 2 cases. And that preservation of districts, preservation of existing district lines, it's not the same exact words as least change, but it's talking about the same concept, that you leave in place as many of the existing districts as you can.
So you're saying it flows naturally from
That's
what
right.
you said before?
It does, and the court has specifically identified preservation of districts as one of the historical redistricting principles. So we've got the traditional, we've got the historical, including preservation of districts, communities of interest, et cetera. So it's already been identified as something that this court considers. It's just that it's never had the opportunity.
Rise to the top. Could I just ask one more question?
Although I think we've exhausted that.
Do any of the other, of the 13 maps, do any of the others emphasize this as a criteria, least change?
I don't believe that they do, Your Honor, but again, I think part of that is that the other maps don't have the same record before the court of how they were created. So we don't have visibility into why most of the other maps ended up where they did. We don't have visibility into how much they took into consideration the district lines in the 2018 map. What we have are maps that are presented to the court, the provenance is unknown, and then a number of the parties put forward an expert to testify about the virtues of the map, but that expert was not the person who created the map.
Other than in Gressman, right?
In Gressman, we know that it was created by an algorithm. I don't know, I haven't seen the code for the algorithm, but yes, we know we know a little bit more about the Gressman, but we don't know about why the particular changes were made as we do for the Carter map. And that's an independent virtue.
Justice Donohue has a question.
Counsel, if I might, I've really sort of looked at what your client did in this context, maybe a little bit differently.
Sure.
But I viewed the approach of least change as an approach to creating a new map in this redistricting context. It's an approach to drawing a map, just as the computational redistricting approach that was used by the Gressmans is an approach in creating a map. I don't know what anyone else did, but this court has never blessed any approach to drawing a map. What this court has always done, as my understanding, and Mello is probably, the closest analogy to where we are now, is you analyze the maps that are presented. I mean, it's fine. I appreciate the understanding, the manner in which your client developed its map, but to me, requiring that there's some precedential basis in order to draw a map that way is something that just never crossed my mind. I mean, am I missing something in the context of this was the approach that your client chose to adopt in creating the plan that is now before this court?
So that is the approach, that is part of the approach, I should be clear. So the approach was to start with the 2018 map and to change as little as possible while also adhering to or improving on the 2018's map's performance on the 4 traditional criteria.
And your argument is that created a better map than all of the other maps that we had before us.
I'm arguing that that's one way to evaluate and to separate out the maps. You have a lot of metrics before you and a lot of ways to measure
I
that.
understand that, but I'm just trying to clarify in my own mind, and answer in my mind Justice Todd's questions. I'm at a loss to understand why we would have at any other point in time in our jurisprudence have had to have discussed this manner of drawing a map. We've never addressed the manner of drawing a map, other than to recognize that computers are used to do it.
Well, there are two ways to look at it. One is to talk about how it was drawn, and the second way is that least change is an independent metric as a way to evaluate the maps on the back end. So if you want to set aside how the map was drawn, that's fine. But there's also that it is a metric, and it's undisputed here that the Carter Plan does the best on determining how many Pennsylvanians will remain in the same district they were in 2018. And that has independent value, as recognized by this court. And also, numerous courts around the country have adopted a least change approach, including in Minnesota and Wisconsin, including in this. Right now, there are two other live impasse cases going on around the country, Minnesota and Wisconsin, where courts are taking that least change approach.
Counsel, I think there's probably some value to a least change approach. I'm just not sure. I mean, I'm looking at the maps. We're all looking at color-coded maps. It would have been nice if you all would have used the same colors. But we can all see them. There's no map that really guts the original plan that horribly. I mean, you can measure it by metrics. 80% of the people are together, 70 or 60. But it's sort of like the efficiency gap. What's the material difference between a 1.2 efficiency gap and a 2.2 efficiency gap? What's the material difference between measuring existing lines that are 74% everybody in the same district versus 83%? Is it better? Yeah, I guess so. But is it materially better? But I guess my question is, are you telling me that, I guess I'm trying to understand, you mentioned fairness earlier in your line of argument. How do you define a fair map?
Yeah, and if I could begin, Justice Brobson, by addressing what you said about, are these material differences?
Right.
And I would just say, for example, the attorney who argued before me, Mr. Havestick, you asked what percent does his map retain? It was 76%. The Carter map retains north of 86% of people in their same district. That's over 1 million people in Pennsylvania. So is that a material difference? That's for this court to decide. But these are real differences. And because this court is being tasked with choosing among the maps, at some point this court is going to have to decide, what relative level of difference matters. And I submit that a difference of more than 1 million Pennsylvanians remaining within their home district is one that matters.
Mr. Gordon, I'm sorry.
On the second point, what do you determine to be a fair map?
So a fair map, I think we have to be guided by what this court said in League of Women Voters. And again, the idea is to prevent vote dilution.
Look, I'm sorry, but I know the vote dilution language. It really comes down to splits. It comes down to, is it going to be a lean Democrat or a lean Republican map? That's really the question.
Well, there are a number of ways to evaluate. It's not just
what's your map come down to?
What is my map?
Projected based on past elections.
So it depends on how you look at it.
How about Dave's redistricting? Everybody seems to like to go to Dave's redistricting.
I haven't gone to Dave's redistricting.
If I told you that if it counted leans, that your map is 10 Democrats to 7 Republicans, would you think I'm off?
I would think that I would direct you to Dr. Roden's rebuttal report, where he has that same number in there, 10-7, but he explains that really the most likely outcome from this map is 8 or 9 seats for Democrats because of District 1 and Representative Fitzpatrick, a Republican, outperforming, and because of the fact that one of the remaining districts is basically a toss-up district.
And I guess my final question, because I'm pressed for time and I'm indulging, the chief is indulging me here as the newbie. Your map that you submitted to the special master had a 2-person voter deviation between districts. And under the United States Supreme Court's decision in Karcher versus Daggett, considering the fact that we have 11 other maps that were able to achieve a 1-voter distribution, would suggest that your map doesn't satisfy the 1-person, 1-vote How do you respond to that?
I'm not aware of any authority that suggests that a two-person deviation does not satisfy one person,
No,
one vote.
it can, but Karcher versus Daggett says as closely to equal as possible and de minimis deviations are not permitted. So,
And there are numerous cases that we've cited in our briefing that talk about, that adopt and bless maps that have more than a two-person deviation. And this court in Mello said that and this court in Mello, in fact, chose a map with about a 50-person deviation over a map with perfect deviation. So this court has already decided that minor deviations such as those are not.
we can't supplant the Supreme Court's, United States Supreme Court on one person, one vote.
But what I'm suggesting is that the cases that have come out since Karcher have not said that a two-person deviation is violative of one person, one vote. And I would address also your Honor's attention to the map that we put in with our submission was a slightly revised Carter map.
This was after the special master's record
It was.
closed.
It was.
Did you seek leave to supplement the record?
We did not. We included it here before this court because this court has plenary jurisdiction to do
Should we
justice.
give all the other parties leave to supplement the record to change their maps?
The point of
Would that be
change,
fair?
if this court thinks that would be fair, yes. The point of, can I just explain why we put the map
I
in?
just want to ask you in that regard, did you serve all the other parties with your new map?
It was provided, I believe so, Your Honor. I'm sorry? It was attached to the brief, which my understanding was served on all the other parties. And we did provide a link in the brief to the data, the block files for the map. And the point of putting forward that additional map was not to say you should choose this map. The point of putting forward that additional map together with the declaration of Dr. Roden was to explain that, yes, Dr. Roden can make a map that has only the one-person deviation. To do so, it comes at the cost of introducing an additional split in a voting tabulation district. And this court... Total splits? And I'm sorry, it depends on which metric you're counting by when you say total. Are you including in their voting tabulation splits or not? Okay. No VTDs. So we're fine with the numbers that Dr. DeFord includes in his, that the Gressman petitioners include from Dr. DeFord, with one exception. With one exception, Your Honor, and that is that I believe Dr. DeFord counted the tiny piece of Chester County as an additional split for us. So we did not do that initially. We did not count that following the guidance of this court and League of Women Voters, which said that piece of Chester County better belongs with, I believe it was Delaware County.
In conclusion, are you asking that we, as we deliberate, look to the original map, look to the map attached to your brief, or look to both?
We stand by our original map. We don't think that a two-person deviation is at all violative of one person, one vote. We submitted the other map. If this court disagrees, then the other map is available for this court's consideration as well.
There's not any case, is there, that says a two-person deviation is anything other than de minimis, is there?
I'm not aware of any, and that's what I was trying perhaps inarticulately to say in response to Justice Bronson.
19 is too much, and the problem is, where do you draw the line?
The problem is, where do you draw the
Problem in all
line?
the law.
Yeah.
And that was the concern expressed by the Supreme Court in Karcher versus Daggett, is there was an argument for a de minimis deviation. And the United States Supreme Court justices said, what's de minimis? How slippery of a slope that is. And if we set a standard that's de minimis is okay, then people will draw maps to a de minimis standard versus striving to get to equal population. And that was recognized in Veith versus Jubileer, which is a district court panel decision back in 2001, I believe, here in the Middle District. So although there's no one that says a two-person split is a violation, the United States Supreme Court has said there's no such thing as a de minimis split.
Yeah, and again, I would direct this court back to what this court said in Mello about additional, very insubstantial splits can be justified specifically to decrease the number of splits in precincts, and that's what happened here.
And they were up to 63.
Yeah, it was 50 to 60, and the court adopted that map over a map that had zero deviation whatsoever.
I can understand your point with regard to the Mello case, But given the fact that League of Women Voters is a more recent case and specifically sets forth as a criteria that you do not split counties, cities, wards, townships, your map, frankly, has one of the highest number of splits of all the maps that were submitted before this court.
It actually has the lowest number of county splits, and you've heard testimony about why county splits are perhaps the most.
14 counties, 31 county pieces, 20 municipalities, and 41 municipality pieces.
So, and just with the one clarification that I mentioned to Justice Todd, depending on how you count that discontiguous tiny piece of Chester County,
Give you one.
it ties, it's either tied for or second lowest on the county splits.
Justice Dodd has the final question of the argument, absent anything any interest she piques among others.
All right, Mr. Burton, should we consider as a factor whether or not
So incumbency pairing is one of these other ones that was mentioned in League of Women Voters, mentioned in Mello as one of these historical criteria. So it is something this court can consider and perhaps ought to consider. And I would. That's correct, and I think as Justice Weck maybe pointed out in questioning of Mr. Haverstick, the Reschenthaler plans go beyond that. I would urge this court to look not just at the bare numbers on incumbency protection, but this is also where lease change comes into play, because you may have an incumbent who technically is not paired with another incumbent, but whose district is no longer the district that he or she represented before, or is just a mere shell of it. So I think incumbency protection is something that should be looked at together with lease change.
Well, I'm sorry, it did pique my interest. Above all, this is not about personalities, right? Because any one of us could get hit by a truck tomorrow, God forbid. It's about population loss in this context.
It is, and that's.
The areas, the big swaths of the state that had the biggest population loss, or some of the biggest ones, were up there, right? Where that happens to occur.
That's exactly right, and those districts had to expand. And so you have to pit some incumbents against each other. And it's in those areas of the state where the districts are expanding much more than in other areas where it just makes the most sense that incumbents will get paired.
Council, back down into the weeds. The map the plan that you submitted splits Williamsport. Is there a reason why that had to occur?
I don't know that there's a specific reason why Williamsport was split.
Because you're the only, aside from the city of Pittsburgh issues that we had, it's the only map that otherwise splits another city.
What I can tell you is that I think, as everybody acknowledges, there are trade-offs. We kept the city of Pittsburgh whole. We reunited Harrisburg with its suburbs. We kept Northeast Pennsylvania whole. We kept Bucks County whole. So,
Something had to give.
We had to split, everybody has to split Philadelphia, yeah. So it's
some way, yeah.
it's a trade-off, but I think if you're looking at the kind of the communities of interest, you could take a look, among other places, at the brief submitted by the Ali interveners, who kind of have a chart about what they view, based on testimony at various public statements, what they view as the most important communities to keep whole. The Carter Plan is the only one that keeps those four whole.
I would just comment on the amicus brief that we received from a Williamsport-Lycoming area that disfavored your map because it didn't consider the community of interest in that Tioga County regularly and frequently combines their employment and their services, medical care and whatnot, into Lycoming County, which is Williamsport.
I'm sorry, I didn't hear the last part of your question.
That the community of interest metric was not observed for that area, in that the community of Tioga County frequently goes to Lycoming County, the Williamsport area, for groceries, for employment, for health care. And so there was some disconcerted people in that amicus over your map.
If you've never been to Williamsport, it is the home of Little League Baseball, by the way.
I know, it's on my bucket list. It is. And I guess, Justice Mundy, my response would be similar to my response to Justice Donahue. I don't think any map or any map maker is going to be able to draw a map that everybody agrees keeps every community of interest together, and you're going to find dissension. And I would just submit that based on the evidence that was developed before the special master, based on what else we've seen, the Carter map does a very good job of keeping many communities of interest together, and in fact reunites some that were split by this court in 2018.
Thank you very much.
Nice job.
Thank you.
Next, we have the Acting Secretary of the Commonwealth, Ms. Chapman, and the Director of the Pennsylvania Bureau of Elections. Governor Wolf, is that correct? If we can do it in one argument, we appreciate, we really do, your brief and the insight of the Acting Secretary and the Director of Elections apropos of the maps. On the other hand, it's not quite the morass that choosing a map is. We got calendars, and we understand we have a May 17th primary, and we know what we have to do.
Thank you, Your Honor. That sounds like a fine approach from my perspective, so I will first speak on behalf of the Department of State, the respondents on the calendar, and then when the court is satisfied with that presentation,
Why
I'm
don't
happy.
you tell us who your counsel is so we don't have to interrupt you later?
Thank you, Your Honor. Robert Weigel on behalf of the respondents, Acting Secretary of the Commonwealth, Lee Chapman, Director of the Bureau of Election Services, and notaries Jessica Mathis, and also intervener respondent Governor Wolf. My co-counsel, John Hill, is here with me today. And if I may, I'd also like to acknowledge my partner, law partner, Carrie Rice, who's not able to be here, but worked extensively on the briefs in this matter.
Thank you.
Respondents are, as the Chief Justice has pointed out, in a bit of a different situation than the other parties in this case. They have not proposed a map. The governor has proposed a map for the executive branch. So respondents see their role here less as advocates for a particular outcome than to represent an administrative agency that is tasked with ensuring that elections in the Commonwealth are run fairly, lawfully, and orderly, and to help the court with the task of devising an election calendar that now I think we can all admit needs to be altered because of the delays in the redistricting process, both on the congressional side and on the General Assembly side. So we have undertaken, the department's undertaken, to come up with a schedule that we believe is feasible and will allow all of Pennsylvania's primary elections. So just to put them into categories, we have the statewide offices, no district issues there, thankfully, but we do need to have those primaries. We have the congressional elections, obviously, that we're all addressing here today, and then we have the state legislative elections. Of course, that calendar is more delayed than this one because of the Legislative Reapportionment Commission process and the constitutional timeline for that. But nonetheless, we think with some modifications that we've proposed, we can keep all of the primaries on May 17th. And that's the department's strong preference from an administrative standpoint for, I think, two primary reasons, which I'd like to articulate just briefly. One is if we were to divide the primaries, in other words, if we were to keep the congressional and statewide primaries on May 17th, but move the state legislative primary to a later date, that imposes some very significant costs. One, there's an obvious risk of voter confusion or at the least depressed turnout relative to a unified primary. Two, and this is particularly acute from the standpoint of the counties who actually directly administer the elections, it's going to make recruiting poll workers a challenge, right? If they have to have poll workers on May 17th and then at some point not too distant from that for a second election. And third, obviously the monetary cost. It's going to cost the taxpayers of Pennsylvania, I think our conservative estimate is at least tens of millions of additional dollars if we have divided primaries. Now, I think there's been some suggestion, at least among some of the amici who have submitted briefs, that perhaps we should just move all of the primaries, keep them unified, but move them to a later date. after May 17th. We don't think that's necessary for a starting point, but we also think that runs some risk as well. In particular, as the court is no doubt aware, there have been a number of lawsuits that have been filed already raising potential elections clause issues that, according to the litigants, arise if the court issues orders with respect to federal elections, so the congressional elections. I think there's no question that the elections clause doesn't have any bearing on the state legislative elections. We think that the merits of those lawsuits are very much debatable, but we do think that it would be better to avoid giving ammunition to them by moving the congressional primary date, particularly where it's unnecessary. I think if it were necessary, then we'd have a different perspective. So the court has our submission, and I won't take you through all the details, but let me just sketch out how we envision this May 17th primary date would work under the modified calendar that we propose. So first, the congressional and statewide elections, because we propose two different calendars, one for statewide and congressional, which doesn't have to be quite as compressed because of the timeline for redistricting, and the other for the state legislative calendar, which does have to be somewhat...
All culminating in the same...
All culminating on May 17th. So the preliminary deadlines are different for those two calendars, but they both get us to a common unified May 17th primary date. So as to the congressional calendar, we would propose a 2-week nomination petition circulation period instead of the usual 3 weeks, and then 9 weeks from the close of that circulation period until the election day itself, as opposed to the typical 10 weeks.
Mr. Wiggle, I think your 2 minutes are up. What I noted in looking at your proposal was the first day to circulate nomination petitions for the congressional races you proposed was March 20th. Is that correct? I'm sorry, it was
March 1st, Your Honor, if I'm understanding. The first day to circulate and file nomination petitions under the statutory calendar is February 15th. But obviously,
Right.
That day is come and gone. We're proposing March 1st, 2022.
what occurred to me immediately, and we'll see how the court does with a very difficult task, but assuming for a second that we choose a map today, we may be able to enter an order setting forth, as you did, a comprehensive schedule, and we may be able to start the circulation period next Wednesday or Thursday or Friday.
And Your Honor, I think that would be wonderful from my client's perspective. I think the more time, the less we have to compress, the better. We were obviously trying to be solicitous of the fact that the court may want a certain amount of time to deliberate and make its decision.
No pressure, no pressure.
What we would have to do is order opinion to follow, but we may have to do that anyway. It's going to take some time to write this. So, but feel free to go ahead. I appreciate you've done a lot of work and you're here today. But I think, let me speak only for myself because we haven't deliberated it. I think that because we're here today, we're going to be able to pick a map. I think we're going to have time to provide 3 weeks to get signatures, enough time for objections to signatures in the Commonwealth Court and our court, and then enough time to do an election. I think the date that's probably most important from your clients is what's the drop date that we have to have all of this to you so that you can send out military and overseas ballots, and so you can print ballots, and so this election can go forward.
So I think there are two key dates there, Your Honor, as I understand it. One is the date where we have the map in place, where the court issues the order, both here and on the LRC side. And we have, again, the court may be able to do it earlier. That would be terrific from our standpoint. We propose that if we were going to be able to start the circulation period for congressional and statewide on March 1st, as we propose, then we believe we would need the final map in place from this court by February 27th. And the issue with the lead time is the following. Before 2011, with the advent of databases and computers, this was all an analog process, essentially. And we are proposing, in order to accommodate the schedule, that we could use that again. And that's the reference to generic petitions. So instead of taking the time that would be necessary to essentially program the map into what we call the SHORE system, the database, we would simply use generic petitions as we did before 2011. The difference is it's a little less hand-holding for the candidates. If we have the SHORE system data programmed, candidates can say, here's where I want to run, and it will print out the petitions, and it will tell them what the district number is, and it will tell them what counties they need to get signatures in. They need to figure that out for themselves under the generic plan as they did before.
February 27th this year.
February 27th on the congressional side. Now on the state legislative side, we have said that if the court is able to issue a decision on resolve the appeals from the LRC's final plan by March 18th, then we could start the nomination petition circulation period by March 20th, which is in accord with that proposed calendar that we've laid out. And I noted yesterday that the court did issue an order regarding briefing in those appeals so that, as I understand it, the appellant's briefs are going to be due by March 7th and responses by March 11th. And I think that that will go a long way, hopefully, to allowing the court to resolve those appeals in a very expeditious manner.
You know, Mr. Weigel, this is not a task that we ask for, right? We get it because the legislature and the governor cannot agree.
Indeed, Your Honor, and I fully appreciate that, and the Department of State appreciates that, and we realize that just as the court is not a map maker, the justices on this court are map makers, they're most of them at least, I assume, are not election administrators, and that has its own set of challenges, and that's why, again, the Department of State, of course, will do everything it can to implement and comply with whatever schedule the court sets forth.
Mr. Weigel, if I understand, just to get concrete here, the department thinks there should be 2 to 3 days between the map and the beginning of signature collection, so people can be organized. And the congressional side, the department would like the map on February 27th. And on the state legislative side, the department would like the map by what date?
March 18th, Your Honor.
Or before.
Or before, yes, that is the last date by which we think we could adhere to the proposed calendar that we set forth. Yes.
We intend to do our best. I mean, we're a group of 7 and we have difficult issues, but to exceed those minimum requirements.
Well, my client's great appreciation for that, Your Honor. And of course, if the court concludes for whatever reason that what we proposed isn't feasible, although I get the sense that may not be where the court comes out, we'd be happy to also then address that alternative scenario if need be. Before I move on, if the court would like, I'd like to address a few of the concerns that were raised in some of the amici submissions regarding our proposed modifications. There was a submission by the petitioners in the David lawsuit, and they raised 2 issues. I think first, they I think raise a complaint or a concern that the period that we lay out in the proposed congressional.
Mr. Weigel?
Yes.
I always want to be polite. I promise you we got the times and that we're going to comply. And I mean, I can't absolutely promise, but I feel every confidence that this court is sensitive to the needs of the people of Pennsylvania, sensitive to the needs of the government of Pennsylvania, and we're going to accommodate your times. And you don't have to worry about countering other arguments. I mean, you're here in good faith, you're part of the Commonwealth government, and we accept what you say. So maybe you want to argue, and we're trying to move forward, but it's an extraordinarily important matter, so we're trying to balance. Maybe you want to tell us why Governor Wolf's map's the best?
I would very much like to, Your Honor. Thank you. So I will change hats, as it were, and now speak on behalf of the governor. Redistricting is not just a once-in-a-decade exercise in adjusting boundary lines on a map. As this court has recognized, it is an event with profound consequences for the health of our democracy. And I think this court said it well in League of Women Voters, that a healthy representative democracy requires that all voters have an equal opportunity to translate their votes into representation, and that this requirement of giving all voters an equal opportunity to elect their representatives of choice is a mandate of the Pennsylvania Constitution's free and equal elections clause. So I think we can also put that in terms then of what we don't want with a district plan. We don't want what we've seen all too often in American and Pennsylvania history, which is a map that entrenches a structural partisan advantage, because...
Then let me ask you the same question I asked Mr. Levine. Explain to us, please, why, to comply, the map needs to divide the city of Pittsburgh, or Pittsburgh as we call it.
Well, Your Honor, I think that there has been a notion advanced by some of the parties in this case that splitting Pittsburgh is a kind of constitutional litmus test, and if you do split Pittsburgh, you fail. And I would respectfully suggest that that misunderstands the traditional criteria for a starting point.
I don't think that's what we've been saying at all, but with all due respect, I think we're asking whether or why it was absolutely necessary to split the city of Pittsburgh.
Let's not even say absolutely for the sake of argument. Just
Just
explain
necessary.
why is it necessary.
Necessary.
Well,
I mean, you'll agree. You will agree with the premise. It has to be necessary, right?
Well, Your Honor, I think not insofar as that is understood to mean we need to mathematically minimize the number of subdivision splits consistent with population equality, which is how I understand, for instance, the Reschenthaler interveners to interpret that phrase. Because if that's the case, no map in Pennsylvania history, I think, has ever achieved this. Certainly this court's map in 2018 didn't achieve that. You could have an equal population map that only split the city of Philadelphia. It would look very strange. It wouldn't be compact, certainly.
But as a premise, going back, the city of Philadelphia has to be split to some extent because its population exceeds the number of persons in a congressional district. The city of Pittsburgh fits neatly within a congressional district without being split.
And that's true, Your Honor, and my point was simply that if you read absolute necessity in terms of mathematical necessity, then you'd only be allowed to split the city of Philadelphia. No map would be allowed to split any other municipality.
You have to split Allegheny County, don't you?
You have to split Allegheny County, and my point is all of the maps split more cities, including this court's 2018 map, more cities, more counties than is mathematically necessary to achieve population equality. And I think it's notable that all of the maps here on the splits perform very well. They're within a very narrow band.
Mr. Weigel,
have a good
look, we're here,
reason, right?
I'm sorry, no one, except maybe the Amicus Chamber of Commerce, is objecting to the splitting of City of Williamsport, has raised any other issue about a particular split municipality. The City of Pittsburgh split stands out. And I think the question from the court is a very straightforward question, and yeah, I'm going to try and ask it one more time. Why does your map split the City of Pittsburgh?
Because I think you're able to realize some important virtues as a result of that are harder or not possible to realize otherwise. One, you get a more compact map, and I think the testimony from the experts was uniform, both that there are trade-offs between splits and compactness, and they're both important criteria. I mean, I don't believe the jurisprudence ranks the traditional criteria.
Well, let me push back a little bit on that. The Constitution says that, and this is for state legislative maps, incorporated as the floor for congressional maps under the Free and Equal Election Clause. It says territories have to be compact and contiguous. They don't say as compact and contiguous as possible. They say compact and contiguous. It says as nearly as equal population as practicable, which is also the one person, one vote standard from the federal Constitution. But they add this with regard to splits, which doesn't exist in the compact and contiguous. Unless absolutely necessary, no county, city, incorporated town, borough, township, or ward shall be divided in forming the district. So there's no qualifier for compactness or contiguity. How can you then elevate or use that as a justification to get rid of or to sacrifice the split language, which does have qualifier, unless absolutely necessary?
Your Honor, I absolutely understand that textual argument, and I think my
That's what I do. I make textual arguments.
Understood. And my response would simply be, if you look at the history of map making, that can't be the right way to interpret the phrase. It can't be a literal mathematical.
So I should ignore the express language of the Constitution in pursuit of the historical map making.
Your Honor, I think I would ask the court to acknowledge that the way that phrase has been universally interpreted is not as mathematical minimization, but that it is a very important value that we should try to respect political subdivisions, but we also have to realize that value in the context of realizing other values, such as compactness, such as protecting communities of interest, which can be both smaller than and larger than political subdivisions, and also in pursuit of what we think is the bottom line value or goal of the Free and Equal Elections Clause, which is ensuring that all voters have an equal opportunity to translate their political preferences.
What does that,
and
what does,
representation.
Paul, I don't want to monopolize here, but this also goes to the core of the case. What does that mean? Because does that mean that if the General Assembly and the governor, and this is what I'm concerned about, I think all of us agree we never want to be here again. Does that mean if the governor and the General Assembly, maybe even a divided governor and General Assembly, agree with a map that doesn't give an absolute 0% split between congressional seats, say we go to 16 at some point in time, and the map by all political measures looking at past elections and forward elections results in a 10, a 10-8 or something like that, I don't know, something that's not exactly even. Can a voter come, if we go down this road and we say the Free and Equal Election Clause demands proportionality or demands what is being defined as fairness, won't that open this court to a challenge every time a map comes out that favors one party over the other and demand that we rewrite it in the interest of free and equal election to make it equal? Because if that's the case, if that's the test, that every map has to be equal, then we'll be litigating these all the time.
Your Honor, I absolutely understand that concern, and I think the court can avoid it here, and let me try to explain why. I think Your Honor touched on a number of points that I'd like to respond to, including what we mean when we speak about fairness or equal opportunity. And I want to make sure, I've got some boards that I brought to try to illustrate that, which I'll try to refer to in a moment. But I think there is a fundamental difference between a situation in which we have a lawfully enacted map, as we did in 2011, and then someone comes and challenges that map and says, this map is so deficient under the Free and Equal Elections Clause that it violates my constitutional rights as a voter, and this court should throw it out. This court should invalidate it. That's one set of questions, and that was the question the court confronted in League of Women Voters. That's not the question here. And what I would say is, I think we can look at the Constitution, and in particular, the Free and Equal Elections Clause, and see it not just as, understandably, courts tend to look at constitutions, which as a set of rights that are judicially enforceable against the political branches. But I would submit that's not the end of, that doesn't exhaust an understanding of the Constitution, or ought not to. It also can and does, I think, this Constitution and this Free and Equal Elections Clause embodies standards and goals. And we can look to those standards and goals in a case like this in particular, where the court is not being asked, is there some deficiency that rises to the level of unconstitutionality such that we invalidate a lawfully enacted map, which clearly is entitled to some deference, a lawfully enacted map that was passed by the General Assembly and approved by the governor. That's not the situation. And so I don't think this court needs to worry about the kind of precedent that I understood Your Honor to be understandably worried about, which is if we say we're going to take a map here because we think it does the best job of achieving fairness. It does the best job of realizing the Free and Equal Election Clause goal of ensuring, this is the language this court has used, to the greatest degree possible, that all voters have an equal opportunity to translate their political preferences.
And I think that's a fair comparison, and I will agree with that there's a difference between a challenge to a map that deserves some deference because it was passed by the General Assembly and the governor, and we probably shouldn't second guess that unless it is an unconstitutional partisan gerrymander or malapportioned or a racial gerrymander or the things that there's historic precedent to. What happens, though, if negotiations break down between the legislature and the governor, and the governor decides to take the chances with basically just saying, I'd rather just go with the zero-sum game map that the Supreme Court's always going to give me than to negotiate something else?
Well, Your Honor, I think that risk exists on both sides, right, depending on what the court's
I agree with you,
standard
but
is.
how do we ameliorate that risk? How do we ameliorate the idea that the General Assembly and the governor will just say, nah, we're just not even going to do this because the Supreme Court will give us a zero-sum map?
Well, I think it's not necessarily about a zero-sum map. I think what our proposal is in terms of how League of Women Voters and the Free and Equal Elections Clause should be understood is it's really a two-part test. and the first step is you apply the traditional criteria, and you disqualify any map that doesn't satisfy those criteria, those floor criteria. Now, I think it's important to keep in mind that those floor criteria are not an end in themselves, or a better way to say it might be not merely an end in themselves. They are expressly designed to offer a floor of protection, ensuring that voters have an equal opportunity to elect. So that's the first threshold test. And then you take the maps that remain, and then you look and see, well, are there real differences among these remaining maps as to how well they do allow voters an equal opportunity to translate their votes into elected representation.
Do you agree, Mr. Weigel, as previous counsel have, that all of the maps submitted to us meet that minimum foundation of constitutional compliance?
I think I would concede that, Your Honor. Certainly the vast bulk of them do, but I think there are some that clearly do better than others, and I would.
The metrics, they do better than others.
Correct. And I think the way that our expert, Dr. Duchin, analyzed it may be helpful to the court. I think she did concede that as a whole, the maps do a very good job under the traditional criteria. She did think that you could take a kind of Pareto frontier analysis, which you look at when you are analyzing multiple factors or values that have trade-offs between them. And you can chart a frontier where you say, well, some maps may do better on compactness, but those maps do a little bit worse on splits and vice versa, but they're all on the frontier. And she said you could have a first tier of the maps in that regard. And you could have a second tier, et cetera.
This raises an important point that I don't think we've stressed earlier today, and that is that a whole lot of work and a whole lot of effort and good faith effort went into the preparation of all of these maps, and really counsel and the experts and the parties are to be commended for that.
Thank you, Your Honor. I think I agree with you, and I think also there's been some talk about, well, what was the motivation, or the record's not clear on the motivation. I would say, if you look at League of Women Voters, it's less focused on motivation. I think it's true that if you had an unfair map, one that was intentionally unfair would be more constitutionally offensive probably than one that just ended up that way. But at the end of the day, the question is whether voters have an equal opportunity to translate their votes into elected representation. And the maps can't hide now, right? They've all been exhaustively analyzed under all of these metrics, partisan fairness metrics, traditional criteria metrics. So, if there is some flaw there, I think it's fair to assume that it would have been ferreted out.
Well, Mr. Weigel, you would agree that your expert has said that, has acknowledged a lean, geographic lean, based on population in favor, that would lean Republican in turnout of congressional races, and that she made decisions, or she believed decisions were made in the map combat's too strong of a word, to moderate that a little bit. Why isn't that a partisan decision?
Well, Your Honor, to be clear, she didn't make the decision. She was doing the analysis after the fact. She wasn't making.
But she acknowledged that decisions were made to mitigate against what is otherwise a natural geographic lean.
I think there's no dispute that one of the governor's goals or principles is fairness in the sense of equal opportunity I've described. So yes, in that sense, that was a
fairness in that regards makes a decision that would favor a Democratic vote share.
No, I don't think that's right, Your Honor. And I think that what Dr. Duchin said was, if you randomly generated a whole bunch of maps, 100,000 maps, and all you said to the computer was, you've got to essentially meet the traditional criteria, right? You would absolutely get the governor's map as one of those maps. And in fact, you would get, I think, 1,000 or several thousand maps that had similar characteristics to the governor's maps. So in other words, it's a map that is totally consistent with Pennsylvania's geography. The lean that Your Honor is referring to is a reflection of the fact that if you ran 100,000 of those simulations, so 100,000 of those random maps, more of them would have a pro-Republican leaning entrenched structural bias. So the typical map would have a bit of a bias. Right. But the notion that we have to, in any way, sacrifice the traditional criteria to end up with a map that is fair in the way that the governor's map is fair, that's false.
Explain that to me, why that's what I'm trying to understand. I mean, it rings to me something like you have two NFL teams, right? And one is really, really better, and they play by the same league rules. But every time they play 4 times a year, 3 times a year, one beats the other. But if we put on the losing team one more player on the field, a 12th player, that makes it fair. That makes it a 50% shot that each team is going to win each game. Is that the fairness we're talking about?
No, Your Honor, I don't think that's the right analogy because, again, what we are trying to avoid here and what the typical map, in the sense that Dr. Duchin was talking about, the vice of the typical map is that you end up in a situation where systematically the party getting fewer than 50% of the votes gets more than 50% of the seats.
That's a proportionality.
No, Your Honor, I respectfully disagree. Proportionality is one of several partisan fairness metrics, but Dr. Duchin's analysis is using what she called, and the North Carolina Supreme Court recently specifically endorsed this in its opinion, the close votes, close seats principle. And I think that's a helpful way, and John, if I could ask for your help, of illustrating and cutting through some of the weeds here in terms of what partisan fairness metric are you going to choose, and variations among the different partisan metrics, deciding what elections you look at. This appeals to, I think, a much more fundamental notion of small d democracy, which is you have the proportionality line here. You can look at other partisan fairness metrics like efficiency gap, but there's a more fundamental issue here, which is we don't want to end up in this southeast or northeast west quadrant, because those are situations where if you're landing here, the party getting more than 50% of the votes is getting fewer than 50% of the seats. And I think that, so in other words, those are counter-majoritarian boxes. Those ought to be no-go boxes in a small d democracy. And that's independent of, you can chart it against these other particular, more specific partisan fairness metrics, but I think this really kind of transcends and distills them in important ways. And what Dr. Duchin then did using this analytical method is she took all of the maps, or she took at least some of the key maps here, including the governor's map, and she analyzed what the election results would be using a sample of 12 past elections. And she plotted them as a paintball. And can we show first HB 2146 versus the 2011 map? So what this graph shows is what those election results would be, and the horizontal axis is the number of votes that the parties got, and then the vertical axis is the number of seats. And if you are adhering to close votes, close seats, you want to be at this bullseye, right? You want to have close votes, 50% of the votes should be about 50% of the seats. You don't want to be in these two boxes.
Which is what the 2018 map achieved.
Exactly, Your Honor. And this illustrates that very well, and you can look, I think, at Dr. Duchin's reports. I don't have a board with that, I apologize, but you can see it in the reports. And what you see is that HB 2146, that's the General Assembly's map, performs very similar to the 2011 enacted map in the way that it not only misses the bullseye, but misses it in a way that goes into that northwest quadrant. That is the quadrant of entrenched structural bias favoring Republicans. And if we can yes?
Again, this may be a dumb question, I'm beginning to get lost. Why is this not a proportionality analysis?
Because, Your Honor, proportionality would say that if, for example, if a party got 70% of the votes, it should get 70% of the seats. Close seats doesn't talk about that. In other words, it says nothing about how many seats a party should get if it gets 70% of the votes. It's really focused on avoiding situations where the party that gets fewer than 50% of the seats, votes, systematically ends up with more than 50% of the seats.
But it is similar in the sense that it relies on an artificial statewide vote share in what are otherwise regional elections.
Well, Your Honor, I guess I would dispute that it's artificial. I think there
are no statewide congressional races.
That's correct.
Right. So what you're doing is you're taking a statewide Democratic vote and analyzing it against regional elections.
That is how the metrics proceed, Your Honor, yes. But there are better and worse ways of doing that. For example,
Counsel,
yes.
Can I just clarify that? It's done at the precinct level, is it not?
It is, Your Honor.
The statewide vote share is done at a precinct level.
Yes.
So that the statewide vote is regionalized.
That's right, Your Honor. Thank you. That's a very important clarification. And that's how we're able to take the past election results and apply them to maps that are hypothetical, right, and see how they perform. If I can just show the juxtaposition of HB 2146 and the governor's map. the same basic graph, same elections charting the performance, and we can see that the governor's map does a much better job of hitting that bullseye, and it does not skew in the same way as HB 2146 into that northwest quadrant of entrenched structural bias. And I think that the results of this overlay analysis can be confirmed if we look at a collection of more traditional partisan fairness metrics. Can we put that up, John?
Mr. Wiley, your time has expired. I'm certainly going to permit you to complete your argument and all questions, but you have been at it for 30 minutes at this juncture.
Thank you, Your Honor. If I can just finish, what this shows is under various partisan fairness metrics, how the plans perform and how they compare to the typical, to go back to Justice Brobson's question, the typical map in an ensemble of randomly generated maps. And here, the closer you get to zero, the closer you are to fairness. So the paler colors are more fair. And what you can see here are a couple of important things stand out. One, the governor's plan is pale across the board, which is reflective of how well it performs under the partisan fairness metrics. Really the best performer, clearly, of all of the maps in this group, although there are some other outstanding performers as well. The last thing I want to note is that HB 2146 is the only map that performs more poorly on each of the 4 partisan fairness metrics than the typical map, right? So it's more unfair even than the unfair typical generated map. And with that, I will conclude, and I thank the court very much for its time.
You did a very nice job. Thank you. I appreciate the explanation. I have all the charges. Hard to understand.
We've learned a lot in the last couple months, Your Honor.
Yeah, thank you. Thank the secretary and the election director for their input. It's important to us that we coordinate. We're probably going to attempt to hear 2 more before we take a lunch break. We'll see how this goes. It's the map presented by Mr. Gressman and Mr. Hirsch is arguing. Yeah, and if we hope to hear the map presented by Representative McClinton, Mr. Senoff arguing, and at that juncture, we'll take a lunch break before citizens voters. So if anybody is here from citizens voters, draw the lines on down to the end, and you want to go take a lunch break, feel free. Good morning.
Good morning. May it please the court. Sam Hirsch for the Gressman Math Science, or GMS, petitioners. With me at council table is my colleague from Jenner and Block, Leslie Harrison. And thanks to the good work of the court crier and the entire court staff, which we want to thank, we have downstairs our Reed Smith team, who have been a wonderful part of this effort, including Shannon McClure and Devin Mazur, as well as Kim Watterson. Thank you for setting this.
Should have brought them up to the surface.
Well, they asked us to limit it to 2 attorneys per team in the room, so I want to recognize them downstairs, though, because they're avidly watching on the screens.
Trying to keep everybody safe. Thank you for recognizing them. And certainly Reed Smith is from our hometown, and we know it well.
Thank you so much. I also want to say that as someone who's practiced voting rights law, how should I put this judiciously, since the last century, and has argued many of these congressional and legislative redistricting cases in state Supreme Courts around the country, I'm just so honored to be here and so blown away by the quality of the discussion this morning. I'm going to talk to you about 3 specific features of the Gressman or GMS plan, but before I do, I want to tell you a little about the clients that I'm so proud to represent here today. These men and women live and are registered to vote in 7 counties spread across the Commonwealth. They come from different academic disciplines. Most are mathematicians, some are statisticians, computer scientists. We have a geographer, data scientists. They teach and research at very different institutes of higher learning, everything from Penn State to Bryn Mawr College.
All within Pennsylvania?
All within Pennsylvania, absolutely. Some of them are in the twilight of their careers and are professors emeritus. Others are rising young superstars in their field. They come from many different ethnic backgrounds. One thing I cannot tell you about them, however, is their partisan affiliation. I haven't the foggiest idea, and I don't care. That's not what brought them together, and it's not what brought them before this court.
Indeed, that's the representation you've made in
Absolutely, Your Honor.
Absolutely fair to say if one were to Google some of the members that are mathematicians, you can see that they have participated in causes that favor Democrats over Republicans. Would that be fair to say? If I were to go through some of the doctors?
I haven't the foggiest idea, actually. I'll take your word.
I'm just asking you because you're presenting to us that they have no partisan politics, yet you're telling us that you don't know. So can we just get to the argument and move politics out of this?
Absolutely.
Well, I think it was relevant to hear that they're not coming from a partisan group.
With all due respect, he said he could not answer that.
Let's proceed.
Thank you. They are here because they believe that what this court said 4 years ago is true, which is that extremely fair and equal maps can be developed with the help of high-performance computers. So they assembled a team of experts, a mixture of PhD computer scientists and mathematicians and attorneys, to look at the long line of cases of this court leading up to League of Women Voters and, of course, including League of Women Voters, distill from that the key principles, translate them into algorithmic instructions, use those to develop literally millions of alternative maps, and use the computer to assess them, driving towards ever better maps, until they got to the point where they had a single map that they viewed as the best one, and that is the GMS map. And I'd like to talk about the GMS plans, characteristics in 3 buckets following the principles laid out in League of Women Voters. The first, of course, being the neutral criteria or constitutional floor. Justice Donahue asked the question earlier, isn't it a floor? Once you're over it, and you move on to other things. I think that's the primary task of the floor, but I do think that far exceeding the bare minimum is actually something to be considered when the court is in this sort of unwelcome position of having to not just eliminate unlawful plans, but choose among lawful ones the very best one. So, on the neutral floor criteria, I'm going to talk about that in a second. Then I will go to how the map helps to give all voters an equal opportunity to translate their votes into representation. And then finally talk about some of the other legitimate objectives that are subordinate to those, but still legitimate and important. As for the neutral criteria that form the constitutional floor, the GMS plan is perfect on population equality, perfect on contiguity, highly compact. In fact, there are only 2 out of the 13 maps here that consistently score better on compactness measures than ours, and the best on political subdivisions.
Fewest splits, you mean?
Yes, 2 things actually. One is the fewest of the 6 types of political subdivisions that get split, and the other is you can always drive that number down by diving into a split subdivision, whether it's a county or municipality, and grabbing a bunch of different pieces and putting them in a bunch of different districts. So we also checked for pieces. So not only how many are split, but how often are they split. And on both metrics, we are first or tied for first.
I don't understand, I'm sorry. The how many are split, I understand, but how often they're split. Could you explain
So,
that?
for example, the 2018 plan, which was beautifully drawn, it did have 4 counties that were split into 3 pieces, one of which is Philadelphia, which had to be, but the other 3 of which were not necessary, but they were additional splits. We got that down to 2 counties. So that's what I mean, is not splitting a county or a municipality or a ward into more pieces, because we think that's also of significance here.
Why don't you split the capital region? That's striking, given that in 2018, we united the capital region, where we're sitting right now. You've got Harrisburg, the West Shore, and Hershey in different districts. And in 2018, one of the many things we remedied was we united those, as well as Northern York, right? Can you explain your rationale?
I can. We, in general, tried to pay a lot of attention to metropolitan statistical areas and combined statistical areas, which are regions recognized by the Census Bureau and the Office of Management and Budget. They're quite objective. Here, this particular formation, particularly districts 10 and 11, were driven by extremely high compactness. So, which is a constitutional criteria in a way that communities of interest is not. So that, I believe, is probably what drove this. But returning to the constitutional criteria, I do want to talk about cities. We are one of only two maps.
I apologize. Before you get to, and again, every expert uses different statistics to measure everything and every data points. And I've tried, as I've looked at this case, to try to find whether it's reliable or not. It seems to be consistent. Dave's redistricting. And your map scores a 46 on splits. Apparently, the higher the number, the better. Governor Wolf scored a 41. The House bill had a 55, which means, at least according to Dave's redistricting, it's better on splits. So as I look at Dave's redistricting, the maps I'm looking at least they don't have you as having the highest score on splits.
So I've never sent, and I don't think anyone on our team has ever sent this map to Dave's redistricting. I have no idea how they score things. All I can tell you is that we had an expert, Dr. DeFord, who put into his reports, I believe, unlike all the other experts, comprehensive and consistent statistics on everything referring to all maps, both the parties and the amicis. And when he was cross-examined, nobody challenged his counts. In fact, what happened was there was a parade of attorneys coming up and saying, hey, you have a nice number on this particular measure for my particular map, don't you? And he would say, yes, I do. So I think that the only sort of consistent metrics that I know of in the record are the DeFord metrics, which were attached to our post-trial submission, have never been challenged, and we reattached them to our brief on Monday in this court.
And as you kind of indicated, other parties have referred to those. I don't know that they've relied on them, maybe they have, but they've referred to them. And the HB map, according to your expert in this chart, the HB map had 54 splits. The Carter map had 58 splits, for example. The governor's map had 63, and your map had 49, which was clearly the lowest on this metric, unless somebody can tell me how this was wrong.
It's correct, Your Honor, and your numbers are correct as
Mr.
well.
Hirsch, before we move beyond the important issue of splits and how, the cutout in Allegheny County has been referred to as the claw, and that, it doesn't matter, but gives us nightmares because we go back to Mickey Mouse kicking Daffy Duck or something like that from the old map. Can you tell us how that occurred?
Yes, and the claw reference was actually not to our map, it was to one of the competing maps.
I apologize.
A similar-looking claw coming from a different direction.
There's basically three approaches to Allegheny County that I see in these maps. There's the approach of splitting Pittsburgh right down the middle. It's 300,000 people, obviously fits easily within a 765,000 person district. So that's not necessary, certainly not absolutely necessary. What it does do is it jacks up your compactness numbers because you replace a very jagged municipality border with a straight line. So there's 5 maps that do that. The governor's, the 2 Senate Democrat maps, draw the lines, and Ali. Of the other 8 that keep Pittsburgh intact, there are basically 2 different flavors. There's ones that put in the same district as Pittsburgh the most sizable and Democratic portions of Allegheny County outside of Pittsburgh. And if you do that, what happens is you end up basically with, just to put it crudely, 1 Biden district based in Allegheny County and 1 Trump district based in Allegheny County and flowing outside of it. Once you do that, your ability to reach partisan fairness or partisan symmetry under all the metrics tanks. And that's what we see in the Reschenthaler maps, in the legislature's vetoed map, in the voters of the Commonwealth of Pennsylvania map.
So
The only ones...
we shouldn't be concerned with that. Because as long as it's a contiguous district and it's compact, the fact that Democrat voters happen to be there, what you're advocating for is cracking.
Absolutely not. What I'm advocating for is ensuring across the entire state and ensuring across regions equal opportunity to translate votes into representation. And let me explain how it works.
The Constitution protects individuals, it doesn't protect parties.
Absolutely, and this court held in League of Women Voters that one of the identifiable characteristics of individuals that is protected is not being discriminated against or having your vote diluted on the basis of your partisan affiliation or your voting behavior.
So are you arguing in different parlance, partisan fairness?
Yes, partisan fairness in the very same sense that the League of Women Voters majority opinion put it.
Could I ask you about the part of what you added on to the city of Pittsburgh? You did.
Yes.
The Gressman map does not split the city of Pittsburgh, but it adds, I believe, in whole Washington County. Is that correct?
That is correct.
And what I guess I had it wrong. Washington's down here.
Southwest.
What I'm wondering is, have we put two similar communities of interest together? Is that something that we should consider? You know, Washington County has a corridor of it, at least a substantial edge of it, that consists of townships such as Peters Township and others who are largely commuters to Pittsburgh. They use Pittsburgh for their medical services. As Justice Mundy was describing Tioga earlier, that, at least that section, that northern section of Washington County, commutes to Pittsburgh, shops in Pittsburgh, uses Pittsburgh for other services. To me, I guess what I'm asking is, what was the justification for that, and is there something wrong with tying Washington County with Pittsburgh into one district?
No, I think there's something right with it, and let me mention a few different characteristics. One, if you look at a population density map, whether by municipality or by block group of Allegheny County, outside of Pittsburgh, the densest parts of the county actually are the suburbs to the south. So Mount Lebanon, for example, what's that, probably the third biggest municipality in the county. So we connected those southern areas on over and bridged into Washington County. If you think about it, it's almost like mapping onto the Southern Beltway, you know, Pennsylvania Turnpike 576, because it starts at the airport, right, in Findlay, and then it cuts across the line into Robinson, cuts back over the line into South Fayette, cuts back into Cecil. So those two counties are now becoming increasingly bound together.
Well, and fundamentally, Washington County is, at least according to the Census Bureau, the U.S. Census Bureau, Washington County is part of the greater Pittsburgh metropolitan region.
Yes, and there's only 6 counties that are, and if you look at them, there's only 2 that are large enough to actually perform this function of fleshing out 2 full districts along with Allegheny. It would have to either be Washington or Westmoreland. They share the 2 largest borders, but Washington is actually the faster, like Allegheny, is a fast-growing county, and like your home county, Butler. Those are the 3 that are, in the last decade, actually more relatively fast-growing compared to the others in the metropolitan area. So we stay within the metropolitan area, we respect density, we respect growth patterns, and at the same time, you don't create any kind of needless partisan bias.
Follow up on Justice Todd's question. It seems you're ambling down the lane of communities of interest here. What was your rationale in uniting the city of Pittsburgh with Washington County, given that it has not been so united with congressional districts, I don't think ever, as far as I know? Number one, and number two, you're now separating Pittsburgh from the Mon Valley and the eastern suburbs, with which it has been united for some time now.
Yeah. Well, just to be clear, we did not take a least change approach, which I suppose is sort of, in a sense, what your question gets to. So we did not put a huge thumb on the scale in favor of leaving things alone, except through indirect means, like trying to avoid the pairing of incumbents. So
Why would protecting incumbents, why would protecting incumbents vault over our painstakingly constructed 2018 plan in importance?
I'm not saying it does, and in fact our map does quite well on lease change, but
Henry Clay and Daniel Webster and Sam Rayburn, why would that be holy writ? I just don't understand why that would trump our 2018
It's not that it trumps it, but this map in this part of the state has extremely good compactness, except where it follows the jagged Pittsburgh border. It keeps Washington County whole. It keeps all the counties in the metropolitan area whole, except for the two that have to be divided, Allegheny and one other. And it, as we just discussed, does respect a community of interest. At the end of the day, you know, difficult choices have to be made here, and
Yeah, and it's true, and you know, part of the factor is why are the choices being made, which is why you're getting the questions. And I think, again, to Justice Weck's question, I appreciate him expressing concern about South Central Pennsylvania, where I currently reside, because I do think it's interesting that your map takes the city of Harrisburg and puts it in a largely rural congressional district, spanning out west to include Huntington County and part of Blair at least, whereas that's not even close to the media market that Harrisburg is in. Harrisburg is in South Central media market with York and Lancaster and Lebanon, and you seem to be sending it out west.
actually, I don't think that's, oh, yes, I apologize. Yes, you are correct there. Let me talk, though, about what I think is really, at the end of the day, the most important thing for us to focus on here, which is that equal opportunity to translate votes into representation. The whole idea is treating people with a history of voting for Democratic candidates and a history of voting for Republican candidates in an even-handed and symmetric way. And there is a variety of measures in the record, and on virtually every single one of them, we're in the top 3, and on the vast bulk of them, we're the top 1. So at the end of the day, when you have to choose from among lawful plans, you have one here that is extraordinarily fair across the board. Second in efficiency gap, third in mean median, but first in mean median if you focus on the most recent elections. And under the Plan Score website, which I think is probably more reliable, frankly, than Dave's, you see that we come in first on every single measure of partisan fairness. But we also understand that the equal opportunity to translate votes into representation applies not just to Republicans and Democrats, but to the growing population of Latino voters and black voters in the state, and our map respects that in a way that no others do.
Arguably, you do more than respect it, counsel. I mean, do you in seeking this noble objective of minority opportunity, run us afoul of the Voting Rights Act in the other direction, such that this goes right to SCOTUS?
Absolutely not. Absolutely not. The only issue under the Voting Rights Act would be if we were actually diluting the voting strength of white voters by creating such a large number of minority districts that white voters were being disempowered, and that's not possible here because we have 3 minority opportunity districts, 14 out of 17 that are not, which means slightly super proportional representation for white voters. So there's zero risk of that.
Why you're pushing way out.
The initial decision was made based on the neutral criteria, though.
Absolutely.
And is this incidental, then, that you end up with a minority Latino district?
It largely is. It's not majority Latino, but it's a majority minority district where Latinos are the largest minority group.
I'm
and,
sorry,
and
I said
that
wrong.
No, it's no problem. But it spills over a little bit into Bucks County because the minority population is spilled over into Bucks County. That part of Bucks is 27% minority.
Hold on, if Justice Wecht he got trampled on a little bit. If he has
I
something
cut him
else,
off, and I'm
let
sorry.
him ask, then Justice Brobson, and then we'll continue.
I apologize, Justice.
No, not at all, Justice. You anticipated where I was heading was, I think it's more than a little into Bucks. You've pushed way out into Bucks, and that got my curiosity aroused as well, because then correspondingly, pushing out into District 1 that far means you have to push in to District 4 a corresponding distance. It's quite a swiveling of the compass, or that counterclockwise movement seems to have a significant impact. Can you justify that?
Absolutely. So first of all, the core retention on District 1, the one that you say swivels around, is approximately 75%. So that district has changed, but it's not changed enormously. As for the Bucks County piece of District 2 in our map, That's the map that starts in, that's the district that starts in northeast Philadelphia and continues into parts of lower Bucks County. It picks up Bensalem, Bristol, a piece of Middletown. That piece of Bucks County is 27% minority as opposed to the rest of the 13% minority. It's got 3,200 people per square mile as opposed to 800. It's a much more densely populated, more minority. It's got a median household income in the low 70s. The rest of the county is 6 figures.
It's got Sesame Place. This is very
Well, it fits well with Northeast Philadelphia. In fact, one of the lawyers in the trial said, you know, I used to drive and bike as a kid back and forth over that line. I could never figure out whether I was in the city or out of the city. But, you know, they also, sometimes we look at school districts. There are 9 school districts in Bucks entirely in our District 1. There are 3 entirely in our District 2, and only 1 that gets split. So we follow school district lines pretty well in addition. And if you look at the 2 groups that actually took on community evidence, the Ali amici and the Draw the Lines amici, they both did the same thing in different ways, but they ran over that Bucks-Philadelphia line precisely because the Latino community had asked them to, and because they saw commonality on both sides of that line. They did it in different directions in terms of which way their districts ran, but they did not view that border as sacrosanct, and I think they're correct.
Justice Robinson?
I mean, Justice White was hitting on it, but I wanted to get back to something you said in front of Justice, in response to Justice Todd's question. Are you telling me that all of the outcomes in this map, particularly the majority district outcomes, the Voting Rights Act outcomes, and maybe even the projected split going forward in terms of Democrat-Republican outcomes is happenstance?
No, I apologize. Let me make this exactly clear. So primary focus was on all the lawful criteria, and that included thinking about the Voting Rights Act and thinking about minority electoral opportunity as we see it under the Free and Equal Elections Clause. What that meant is that just as we were looking at the 18 statewide general elections when determining partisan fairness, we looked at those plus a body of 17 primaries, 10 statewide, 7 local in the Philadelphia area, when we were looking at minority opportunity, because minority voters sometimes have their opportunities squelched by losing, by their preferred candidates losing in the general election, and sometimes because their preferred candidates lose in the primary, their preferred primary, which in this area is always the Democratic primary.
Your map, and the answer to my question is, your map was designed to achieve certain things, among which to improve minority voter opportunities, to create a map where Republicans have, or Democrats have just as much of a chance to win seats as Republicans do, or maybe better, depending on if you use this argument dealing with statewide voter distribution. I mean, at least Dave's Redistricting has your map as a fairly favorable Democratic map.
Okay, well, on the partisan point, no, it's not Democratic favoring. Every metric but one in the record here shows it to be slightly Republican favoring, including every metric under the public and neutral and transparent Plan Score website. There's only one map of the 13 in front of you that's actually Democratic leaning. That's the House Democrats map. On the piece about the minority districts, there, yes, we were looking at who is the Latino preferred candidate, who is the Black preferred candidate in the general elections and in the primaries, and seeing if we could create more opportunity, not beyond superproportionality for sure, but up toward getting proportionality that would reflect the growing diversity of the Commonwealth. And we found a combination of geography that works for that.
First, Matt, your time is running short. I have a really specific question that's been lurking as I prepared for this. Again, over in our neck of the woods. I think, and correct me if I'm wrong, because this is layers upon layers, that Congressman Rathenscheller hails from Washington County. And we neither want to be political, nor do we want to be perceived to be political and engaged in some sort of gerrymander to impact counties. He's an incumbent congressman, I think an up-and-coming young Republican congressman. If you combine Washington County with Pittsburgh, as you did, does he lose?
I don't think so, for the same reason that Congressman Fitzpatrick doesn't lose. These things aren't perfect. I mean, someone talked earlier about, aren't we just sort of projecting from statewide elections? And Professor Roden's expert report says, yes, we do, because they're very good indicators, but they're not perfect. Matt Cartwright wins a Trump district. Congressman Fitzpatrick wins a Biden district. So there are crossovers like this. We understand
So
that.
then what should we be shooting for?
A fair allocation based on the largest body of statewide elections
Well,
available.
see, again, I don't understand what the difference between that and proportionality is.
Oh, here's the difference. Our principle is majoritarian. If Republicans in November get more votes statewide, they should get more seats. If why?
Because a statewide race is a
I'm not
statewide
even saying a
race.
statewide race.
Congressional race is a district.
No, I'm saying if you tally up the congressional vote across
No,
17 districts.
I understand, but you're assuming it's a single-member district election.
Yes.
But that's not how we elect Congress people. We elect them by districts that have neutral boundaries that are supposed to be drawn.
I think you're misunderstanding what I'm saying. What I'm saying is if you total up in December what happened in November, and Democratic congressional candidates got more votes than Republican congressional candidates, they should get more seats, and vice versa.
I know, but
That
that's
seems
a
fair.
statewide total.
It is a statewide total.
That's the
correct.
point, is we don't elect statewide, we elect regionally.
Right, but the only answer to that is to completely ignore partisan fairness in this process, and the League of Women Voters decision says don't do that.
Don't you distinguish, and we're going to conclude, and appreciate your coming from New York to do this and share with us. Don't you distinguish between partisan fairness and proportionality, as Mr. Levine argued first thing this morning? And if you do, can't you be partisan fair without being proportional?
Absolutely. Proportionality says if you get 57% of the vote, you should get 57% of seats. If you get 42%.
You're not arguing that.
No, absolutely not. All we're saying is there shouldn't be something that systematically expands the chance of sort of a wrong winner, where one party gets most of the votes, the other party gets most of the seats. That's the thing you're trying to avoid. Because if you were operating behind a veil of ignorance, and you didn't know which side you were going to be on, that's what you'd want in a map.
I understand.
Counsel-
Justice Donahue's got a question, Justice Todd's got a question, and we're going to respectfully wrap this up.
My first statement is not a question. It's my thanks to your expert for doing the apples-to-apples analysis that happened in this case. Because otherwise, we'd be left with, I personally would be left without a measurement tool. But this notion of partisan fairness, I mean, this is something that is capable of being captured scientifically, is it not?
Correct.
And isn't that what all of the discussion about mean median scores and efficiency gaps and things of that nature, and they may not be perfect,
Correct.
but they are scientifically based predictive tools as to what an outcome of an election is going to be, using historical election information put down to a precinct level in order to determine what will happen in any particular district. Am I understanding that correctly?
Exactly. And we looked at 9,178 precincts across 18 statewide general elections, going all the way back to 2012. And we found and Plan Score, an independent operation, found that our map was the least biased, the most respectful
Let
of
me
voters.
just get back to what we have in this record. I don't know about Dave's districting. I never know how to use that app, so I don't look at it, because we have a record here. So here's what I'm just trying to capture. When your expert did his apples-to-apples analysis, and let's look at and I'm using the term loosely, partisan fairness, because that encapsulates a number of different scientific measurement tools. He used the 18 statewide elections, and if I'm understanding correctly, he used the 2017 Supreme Court race. Is that accurate?
Yes.
I don't quite understand that, just because it seems to be an outlier and I don't know what kind of a difference it made, but could you just explain to me, for my analytical understanding, why that happened?
Yes, his rationale was laid out in his report, and I believe in his testimony. There were 17 even-year elections, and they divided 13 Democratic victories and 4 Republican victories. Moreover, none of the Republican victories was by a very sizable margin. The biggest one was Mr. DeFore for auditor in 2020. Meanwhile, the 10 biggest landslides, so to speak, were all on the Democratic side. So he thought it was important to have some election where a Republican won by a large margin, congratulations, and he wanted to analyze this, what would that look like? So he put the 2017 election. The secondary reason, I believe this is in his report, I'm not sure, is it also was a biracial election where there was a candidate of color.
Okay, so when he did the, I'm going to use apples to apples analysis, he used the database that included the 2017 Supreme Court race.
Yes, although he also said that his overarching conclusions would not have been altered by eliminating it.
Okay, let me just ask you one more metrics question, so to speak. I'm looking at the efficiency gap scores that he plotted. It's on page 15 of his experts report. Explain to me, as the unindoctrinated in mathematical analyses, what the significance is in the difference in these scores. You have a minimum score, a maximum score, a mean score, and then a range.
Yeah.
In analyzing this information, let's take the GMS range of 0.194, and just for sake of analysis, take the House Republicans' score of 0.31. Is that a significant differential, and how does that translate into percentages, if that's possible?
Your Honor, the most important line is the one right above it, the one that says mean score.
Okay.
And there we are at 0.8%. The House is approximately, if I'm doing the math right in my head, about 8 times higher at 6.3%. 6.3% is getting up into the range where other courts around the country, before Rucho and federal court and state courts like North Carolina, will actually strike down a map. So that's getting up towards the range where you really have to worry about, even if we're passed by a legislature and signed by a governor, it might just be unlawful.
What is that? What is the range? What is the outlier range? I've seen 10%.
I think the academics who put this together, Eric McGee and Nick Stephanopoulos, have said 7 or 8% should definitely be presumptively unconstitutional, and sometimes numbers lower should be as well. So it's in that ballpark.
But there's no, Justice Donahue's question, there's no map here that has an efficiency score in the gerrymander range. Nothing compared to what was struck down in the League of Women Voters case.
Nothing compared to the 2011 map, but you get in the Reschenthaler map 7.8%. That's getting up to where the academics say that should be presumptively unconstitutional, and where there's actually plans like that have been struck down in other states. I think the only ones that are close calls are the 2 Reschenthalers, the vetoed plan, and the voters of Commonwealth of Pennsylvania. But the point is, you're not in the position here of having a legislatively enacted map with those numbers coming to you. You're in the position of just picking the best of a bunch of lawful maps. And, you know, these are great maps. It's not, I don't want to leave you with a sense that we're like the only one with a good map. There's a lot of good maps here.
We've come a long ways.
Yeah, and it's because of you guys. I mean, look at how you've narrowed the field because of League of Women Voters. People don't come in here with these crazy, goofy, kicking Donald Duck, you know, ridiculous maps anymore. It's wonderful.
Some of the people championing reasonable maps today were insisting that goofy kicking Donald Duck was a great map.
Well, it wasn't, and you were right and they were wrong. This is just a wonderful case of the whole field looking, in this state, looking so much better than it did in the past.
Counsel, am I correct that your map is the only, in the way you presented testimony and evidence before our special master, Judge McCullough, your expert was the only one who was also one of the map drawers? He was involved in creating the map, or is that not correct?
No, he was not. He's done some academic work with some of the folks involved, but there was an earlier question about, you know, is this all like open source? There's a peer-reviewed election law journal article called Computational Redistricting in the Voting Rights Act that has open source software, which is effectively what was used here. It's slightly tweaked from state to state, but
And that was an effort to eliminate, to the extent possible, human bias.
yes, and I think it did. And the proof is in what our expert testified to, which is not how it was drawn, but the properties of the map themselves, which are extraordinarily even-handed. And if I could close by, do I get my 2 minutes? So, Justice Todd, did I answer your question before I move on?
Yes.
So, in short, we have a map here, the Gressman GMS plan, with perfect population equality, perfect contiguity, highly compact districts, the best record of minimizing the division of counties, cities, boroughs, townships, wards, including keeping Pittsburgh intact. And in terms of equal opportunity to translate citizens' votes into representation, we are across the board the best on partisan symmetry, fairness, lack of bias by all the scientific measures in the record, which include the plan score numbers because we put them in the record for every single map after the Senate Democrats expert raised them in his opening report for some but not all maps. So we put them in for all. And part of the reason is because we have 5 districts that in every general election we looked at went Democratic, 5 that in every general election we looked at went Republican, and 7 that had some amount of swing back and forth. That's a lot of competitive districts. That's a good thing. And we didn't stop by just looking at...
Please finish up for us. You've done a very fine job.
We didn't stop there. We also created what would be, for the first time in the Commonwealth's history, 3 minority opportunity districts, including one that's predominantly Latino. And we haven't talked about this, we did not pair any incumbents seeking re-election. It's a big difference between us and, for example, the Carter map, which decimated Congressman Keller's district, paired him with Congressman Thompson, and used the spare parts of that district to keep their core retention numbers down. We respected the fact that 5 districts across the central part of the state had all gotten below 700,000 people, and that needed to be, that burden of losing a district needed to be more broadly shared. In this case, you need not choose between Republicans and Democrats, between the legislature and the governor, between the Senate and the House, between state and federal office holders. And you also need not choose between the best map on the traditional neutral criteria and the most fair. The GMS map is both of those things, and it comes to you not from anyone with a partisan label or partisan identification, but from a bunch of math and science professors who came here to do a public service and are very thankful to this court for its attention. So thank you very much.
We're going to hear argument finally for the morning, late morning, for Representative McClinton. That's Mr. Setoff.
Chief Justice Baird, may it please the court, David Senoff on behalf of the House Democratic Caucus through their leader, the intervener Joanna McClinton. With me today is Dan Breyer from Myers, Breyer and Kelly. With the court's permission, we would request that Mr. Breyer and I be allowed to split our time. Mr. Breyer's only going to comment with regard to the calendar issues, any particular calendar issues that there are. As I was driving here this morning, I was trying to think, after having tried this case before or presented this case before the Commonwealth Court, how to present this case here. And as I said in the Commonwealth Court, this case reminds me of a saying that my now dearly departed law partner, Bill Caroselli, used to say all the time: I feel like I've brought the wrong file to court. And he would say that all the time, and the reason why I feel like I've brought the wrong file to court is because this is not the League of Women Voters, right? League of Women Voters, you had a map, we had a map. You know, to put this in a perhaps more pedestrian view, if this were a tort case, we'd have a liability phase and we'd have a damages phase. In this case, we don't have a liability phase. This is just a remedies case. Everybody agrees the first map, the current map, the remedial map was great, but is now constitutionally obsolete by virtue of the census. So now that we've gotten past that, and having read Justice Doherty's concurrence when the court took plenary jurisdiction, the questions that remain here today are much bigger than what numbers should we pick and how should we decide what the case should look like. or who should hear the case in the first instance, but instead, the issue here is how do you pick a winner, for lack of a better word, when all of the maps are within a certain range of constitutional fairness. Now, we can have arguments about the fact that on one particular metric, one map is better, on another metric, another map is better, and that's all true, and that's a function of the metrics, right? Because when you give to one metric, you take away from another. So, yes, is the House Democratic map, do we deviate by 2 people? Yes, we do, but in fact, we deviate by 2 people because we try to keep Pittsburgh whole, and we try to do other things in other metrics in order to sort of resolve the problem. But I do think that it's time to sort of say plainly what the League of Women Voters wasn't, the Court and League of Women Voters wasn't asked to say, which is how to break the tie. And I think the problem with people verbalizing that is that I think we just have to come out and say it, that the way to break the tie is that partisan fairness needs to be elevated to what is otherwise a constitutional mandate requiring free and equal elections, right? I mean, partisan fairness, and however that's measured, I know there's 1,000 different ways to measure it, but partisan fairness is the overarching goal here. And we can call it vote dilution, we can call it whatever we want to call it, for example, disenfranchisement, we can call it vote wasting, we can call it any number of things. But at the end of the day, what we're really talking about is whether or not people have the opportunity to cast a vote that's equal to other people's vote and not diluted and not weighed more heavily and none of that. And because the problem is, as Justice Brobson quite rightly pointed out, there's a geographic overlay of this, but there's also a historical overlay of this. And in League of Women Voters, the court recognized, in fact, Table 1 in the opinion sets forth the entirety of the congressional districts from, I think, 1966 until the time of that case. And when you look at them and you add them up, there's a slightly more Democrats elected than Republicans, but it's not tremendous. And there are years where there were landslides, I'm thinking about the 80s, right? Landslides for Republicans, and then there were years where there were landslides for Democrats, and then it balanced out. But that never happened with the 2011 map. It never found a balance. And that's what the remedial map in 2018 did. It gave a balance. And so, the idea that, I think Justice Brobson, you were trying to make that once you put a pen to a map, you've already made a judgment, right? Like, once you decide, I'm going to draw the line down this street, somebody has made a judgment about why to do that, right? And whoever that may be, ideally that would be the legislature and the governor. But once you put a line on any map, you've made a judgment about it. Now, I was the counsel who counsel referred to as riding his bike between Bucks County and Philadelphia in the Commonwealth Court, and I questioned one of the experts about that, because that expert in particular testified, it's once you cross over the county line between Philadelphia and Bucks County in the far northeast, it's like night and day. You can't tell the difference. I mean, I couldn't tell the difference. I played Little League in Bucks County, even though I grew up in Philadelphia, and so. That's why you can't tell the difference. Well, that's true. But there are 4 gas stations on the 4 corners of the intersection, and you can't tell what county you're in when you're getting gas. I mean, the point is, like, these are real-world places that we're talking about, right? These are real-world choices that voters make. Voters do all kinds of things during elections, as we all know. For example, in 2016, President Trump won Pennsylvania. Of course, the highest vote getters in 2016 statewide were the row officers. Attorney General Shapiro got 3 million votes. That was more than President Trump got, yet President Trump won the election. All 3 row offices were swept by Democrats, and yet Senator Toomey quite handily beat the Democratic nominee, Katie McGinty. And so my point is, to Justice Weck's point earlier, this is all just predictive, right? In 2018, you could look back and say, oh, we can see what the historical trend was, and this is out of whack. And so,
Mr. Senoff, you began your argument by saying that under League of Women Voters, partisan fairness should be elevated. I assumed you were going to go on to tell us why your map is the best among these constitutional maps in partisan fairness.
and I'm happy to do that. I mean, look, our map is certainly, by some metrics, not the best partisan fairness, but by others, I mean, we were talking about Dave's redistricting, for example. So Dave's redistricting has the House Democratic map at below 1, but of course, it's not at 0. It's 0.2% lean towards Democrats. And the reason why I was about to talk about the historical trend is because 0.2% means, okay, so maybe one year we're going to have 9 Democrats and one year we're going to have 8 Republicans, and the next year we're going to have 9 Republicans and 8 Democrats, or 10 to 7 or 7 to 10. But those kind of variations are not variations which anybody would look at objectively from the outside and say, this is an issue of gerrymandering because it's always 9 to 8 or it's always 8 to 9 or whatever the case may be.
Yeah, that's the contrast, in other words, with what we saw in 2018, where we could look at that entrenched gerrymander, as opposed to here we have maps that are all within a reasonable range.
Right, and I think when I started by saying this is only a remedies case, what I meant it was, and I'm very serious about this, is that when you're presented with a map and you're asked to make a decision, does the map violate, is it an unconstitutional gerrymander? You need certain criteria
Well,
to
and
be
none of
able
them
to
are.
apply.
Nobody's alleged that any of these maps are an unconstitutional gerrymander.
Correct.
Yeah, so that's, and this is, and what I appreciate, Mr. Stenoff, about your argument so far is you haven't kind of gotten into the weeds. You're speaking a little bit more practically, and that's why I want to ask this practical question. This is my overriding concern in this case, and I may read League of Women Voters way differently than the other 6 justices up here. But what I read League of Women Voters to say was, that's a gerrymandering case. That was a case where there was an allegation that a map was so far askew from natural reality that it had to be stopped. And how were we going to do that? Well, how do we know it was so far askew from natural reality? It didn't even meet neutral criteria. So it's bad. But then, again, and maybe I'm reading this wrong, and I'm sure my 6 new colleagues will tell me if I am. Then what I think Justice Todd said was, but hold the phone here a minute. You could have a map that meets those neutral criteria, but still be an unconstitutional gerrymander. And that's why we can, that's because mathematics are being what they are, people can get crazy, so you could still have this unconstitutional skew. Do you agree with me so far?
I do.
Okay. This case deals with none of that. This case deals with now taking the free and equal election clause and saying it's not to be used to find and identify partisan gerrymanders. It's to be used as an end. When the General Assembly and the governor can't agree on a map, this court uses the free and equal election clause and this idea of partisan fairness to draw a map. And that's what I'm concerned about, that is, if we do that, if we say this map that we have is now partisanly fair by the free and equal election clause, and we pick a map with certain metrics and this and all that stuff, where do the General Assembly and the governor ever negotiate?
So I take your point. I heard your questions to prior counsel, and I was trying to think about, what's the response to that? And I think the response to that is that we can't know what future governors and future legislatures are going to do, number one. Number two, we also can't know what these maps will produce by way of results, because they're by definition predictive. And so to your point, you're right. This is not the League of Women Voters where we're saying, let's take the neutral criteria, slap it over a map, and figure out whether it's right or wrong. But in many ways, this case and the proceedings below were just a race to the neutral criteria, right? All the evidence was, oh, ours is better under this neutral criteria or this. But you're right, this is not a case where one map has to be determined unconstitutional and then there needs to be a remedy. This is a case where the legislature and the governor couldn't agree, and now there has to be a remedy based on a blank slate because we all agree that the current map is unconstitutional because of the census. And so my point is that in order for it to be free and equal, as Justice Todd said in sort of leaving us in suspense at the end of League of Women Voters, like, but this is not this case, right? Well, so today is this case, right?
What's the answer? What's the answer?
Yeah, I thought you,
It's leading up to the punchline here, but you don't get to it. So this is the case.
So
you want us to pick your client's map. Why?
I think because it's the one that honors partisan fairness in the way that we look at the historical breakdown of the congressional races, in the way that predictively it meets the idea that there is a Democratic voter registration advantage in Pennsylvania, which has always been the case, and in a way where at least some of the experts had said that a voter registration is the best way to predict a voter's behavior, that their public acknowledgement of a particular party that they identify with is the best way to predict that. And so I don't want to go on to a tangent about proportional representation and all that, because I understand it doesn't mean just because there are more registered Democrats that there should be more Democratic seats.
Just if I could interrupt, I'm not aware of any analysis, at least that I've seen, that's based upon voter registration. Every analysis that I've looked at is based upon voter performance.
I understand.
But that's a big difference.
Well, but all I'm suggesting is...
Some Democrats vote Republican, as we know in Westmoreland County. I mean, you know, that's true across the Commonwealth of Pennsylvania, and there are Republicans who vote for Democrats, you know, as we know from the Biden win. So looking at voter registration, to me, is really a non-starter in terms of the analysis that I've seen done. And if you could tell me where the analysis that is done that's based upon voter registration, I'll certainly look at it.
No, it's not that there was, you're correct. There was no analysis done. The court took judicial notice of what is currently on the Department of State's registration website, but the issue is not one or more of these factors, or the issue is actually one or more of these factors. Dr. Dilution testified in specific what she would calculate as partisan fairness, but the point of what I'm saying is that the partisan fairness factor has to be considered when you're in a situation where there is no other way to break these maps down. And
it's different for our court to do that. I mean, we will look to the ideal of Article 1, Section 5, because we aren't involved in a political brokering, which is a different situation than if we got a map that was actually brokered, where the Republicans and the Democrats in the House and the Senate in Pennsylvania got together and agreed on a map. It went to the governor and he approved it, and then there's a challenge to it. That's a different situation than we have now.
I agree. And what
the latitude in that circumstance to deviate from zero may be different. I don't know. That's not where we are. We're in a situation where we have statistics and analyses on the various maps that are before us, and we're in a position of saying, what does Article 1, Section 5 require?
And I agree with you. All I'm suggesting is that, and maybe to Justice Brobson's question
I was
about...
hoping I'd get an answer to mine.
Well, and maybe to your question, which is, you know, perhaps when we talk about the floor and we talk about the goal, that, you know, a negotiated map by definition is a negotiated map. It's going to lean one way or the other because it's the product of a negotiation, right? And there's nothing wrong with that, you know. But
I'm not worried about that scenario.
Okay.
I'm worried about the because
you're worried about people standing back.
That's what I'm worried about. If we as a Supreme Court set down a policy that says when we have a world of maps that are given to us in a hearing, our only choice under the free and equal election clause is to pick the one that's closest to zero. That's our only choice. My concern is if we lay that down, if we lay that marker down, then the governor and the General Assembly in the future risk not doing their job because they'll say, we'll just let the Supreme Court pick the zero map. That's my concern.
And I understand that concern. And what my response is, look, when you have a map and you have to review a map, you have to apply the neutral criteria, right? I mean, these maps have to meet the neutral criteria. So first of all, the governor and the legislature, they can't just stand back, because if they just stand back, then both sides risk either a zero map or a close to zero map. So their opportunity, they have always the first opportunity to act, right?
They're supposed to have the last opportunity to act, too.
Well, and yet they don't take that opportunity. And nobody here in this courtroom is saying that they shouldn't have both the first and the last opportunity to act. The problem is that when they don't act and we butt up against these deadlines, then what do we do? And so I don't think in the exercise of deciding which one of these maps is the closest to the ideal map that this court has to lay down a rule that says there's always going to be a zero map when you come here. I think what the court has to say is, look, first of all, the maps have to meet a certain minimum criteria. We know what that is from League of Women Voters. And then, if we're faced with a bunch of maps that meet it, then we have to look at other factors, all of which the experts in one way or another homogenized into what they call partisan fairness.
Can I interject then, Mr. Senoff, and ask you about those other factors? Could you explain to us why your map's drawing of the arm southward from Butler County in proposed District 16 is the best draw for the city of Pittsburgh as opposed to any of the other maps that we've been presented with?
You're speaking of the claw?
The Freddy Krueger hand.
I was never a fan of that movie. No, I think the goal...
The heart out of our county.
I think the goal, honestly, was to try and keep the city together, right, as a unit. The problem, of course, is that both in Pittsburgh and Philadelphia, Philadelphia in particular, you can't keep together because there's too many people. Pittsburgh, you can keep together, but then you're stuck with having to push around the rest of the county, right? So unless you either cut Pittsburgh in half and push it around within the county, or keep a circle around it and try and draw the counties around it, there's sort of no way to meet the average population for district.
Except that you can keep Pittsburgh together, assuming that's something you want to do, and keep most of the district attached to it within Allegheny County instead of grabbing half of Butler and all of Beaver with the whole city of Pittsburgh. Right?
I mean, I think that's right, and I think there are maps there are other maps besides ours that perhaps draw the western part of the state, differently, that this court might consider to be a better way. But, the point is that the court now can issue a remedy that the court wants to issue. And so it doesn't necessarily mean, I don't think, that the court has to simply swallow whole one of these maps. The court could take parts of these maps, assuming that they fit together, and put them together itself. I mean, there's no prohibition
You're not
against that.
suggesting at this point that we get into map drawing again?
Certainly not. I'm saying on a go-forward basis, there's no prohibition against that happening, and that's what
But
happened in
there's
2018.
no appetite for it either.
Well,
Well, and here you've presented us with 10, 11 maps that are all deemed constitutional.
Correct.
And all deemed more or less partisan fair. It would be absurd, it would be activist to draw a map. We got.
I agree. I agree with that.
Well, putting all that aside, it has a lot to do with the calendar, doesn't it? I mean,
Yes.
Yes.
suppose we had a hefty appetite and we didn't think it was activist, we still have the calendar problem, right?
We do, and before my time expires, I wanted Mr. Breyer to address that exact issue. Thank you, Your Honor.
Thank you very much, Mr. Stenoff. Mr. Breyer?
Yes.
And again, as I said to the representative of the acting Secretary of State, we have a pretty good handle on the calendar. So something that you have to say that would elucidate it would be appreciated, but in terms of getting on a calendar and telling us the dates, we got that.
I have the full sense of that, Chief Justice
Thank you.
Behr. Thank you. And I listened attentively as the court outlined its very close attention to the calendar, both in terms of its responsibility in this case, as well as its parallel and constitutional responsibility in the LRC case. And I rise only to speak briefly to that. I heard the court to say that we will have a unitary primary on May 17, which is, of course, what the election code requires. And on the issue of the parallel proceeding that's coming to the court from the LRC, as the court knows, there's a constitutional deadline of March 7 for appeals or petitions for review. Yesterday, the court entered its per curiam order directing that any response be filed by 2 p.m. on March 11. So, under the calendar as proposed by the Department of State, the Department of State aspirationally urged this court to enter its ruling in the LRC case by March 18 so that petition gathering could begin on March 20. I'm urging the court, as it sets the calendar, to do so with full awareness of that parallel proceeding so that if the court determines that the 4-to-1 LRC map that was approved on February 4th by the LRC on a 4-to-1 vote, if the court determines that that map is not contrary to law, that there is time for the constitutional requirement that the new elections be held on those maps. So the point is this: Article 2, Section 17E provides that if the court finds that the new maps are constitutional, the election must be held on those new maps on May 17.
In other words, I think, and I want to make sure I understand you, there was a lawsuit just filed, I think, yesterday, suggesting that we use the old map, but I think that's premised upon throwing out the new map. And you're here to say to us, use the new map on May 17th. Is that
That's
accurate?
correct. I'm here to say that the new map, you should set a calendar that preserves the opportunity for this court to find that that new map is in fact lawful so that the primary can be held on that new map. And that's the sum total of my...
And that's, again, just as a courtesy, that's what we tried to do yesterday by submitting it on brief absent further order of court, eliminating responsive briefs so that on March 11th, we can caucus, and then goodness knows if we can get 4 votes, but we'll try.
And I understand that and respect it, and I read the order exactly as an effort to get to that result. If you reach that result, and if the court does what it did in Holt 1 and determines the lawfulness of the map within a couple of days, you'd actually pick up a few days under the calendar, which was, I think, Justice Todd's point earlier. So thank you for letting us split our time. I respect it, and thank you for
the help.
Thank you.
All right, we're going to take a luncheon break. We're a little behind, but this is an important matter, and it's worthy of this consideration. We'll come back at 1:35, which is a little more than a half hour. It's about 40 minutes. Okay? Next argument is on behalf of citizen voters. Mr. King.
Thank you, Mr. Chief Justice, Justices of the Court. I want to introduce, first of all, I'd like to introduce you to the very first lawyer from Shakora, Pennsylvania, to ever appear in the Pennsylvania Supreme Court, Michael Shakley.
And in 30 seconds or less, where is Shakora, Pennsylvania? You can point it on your map if you want.
Thank you, Your Honor. My name is Thomas W. King III. I'm with the law firm of Dillon, McCandless, King, Coulter, and Graham of Butler County, Pennsylvania. And I'm here on behalf of the group known as the Citizen Voters. Before you is the map of the citizen voters. But before I get to the map, I took the approach today, I want to take the approach today, to address those things that this court said about its own map in 2018. And what the court said about its own map in 2018 at League of Women Voters 3 was this, that this map is composed of congressional districts which follow the traditional redistricting criteria of compactness, contiguity, equality of population, and respect for the integrity of political subdivisions. The remedial plan splits only 13 counties. Further, this court said, the remedial plan is superior or comparable to all plans submitted by the parties, the interveners, and the amici, by whatever census-provided definition one employs, minor civil divisions, cities, boroughs, townships, and census places. The compactness of the plan is superior or comparable to the other submissions, identifying those other tests. And finally, that no district has more than a one-person difference in population from any other district, and therefore the remedial plan achieves the constitutional guarantee of one person, one vote. In the dissent, Justice Mundy said as follows, recognizing that the Pennsylvania Constitution does not articulate explicit standards to be used in the creation of congressional districts, the majority fashions a three-part test. 1, the population of such districts must be equal to the extent possible. 2, the district that is created must be comprised of compact and contiguous geographical territory. And 3, the district respects the boundaries of existing political subdivisions contained therein, such that the district divides as few of those subdivisions as possible. These vague, judicially created neutral criteria are now the guideposts against which all future congressional redistricting maps will be evaluated, with this court as the final arbiter of what constitutes too partisan an influence. And I believe citing correctly from decisions from the United States Supreme Court addressing what is too arbitrary. So I took the words of the court to heart. I also took the dissent to heart. And in looking at the words that the court used to address what criteria should be used, I went to Judge McCullough's report because I haven't heard anybody say much about it today, but Judge McCullough did a fantastic job in a very short period of time putting together an awful lot of information, and certainly she should be congratulated on her efforts. She reported...
Her hard work, absolutely.
Yes, Your Honor, I agree. And so since she did such a good job, in my opinion, and worked so hard and diligently, I wanted to address at least the core fundamentals of her report with you. And to remind you, I know it's not necessary, I know the court will certainly absorb all of this information, but I wanted to begin at page 206 of her report. And the court, as this court knows, I believe, Dr. Dilution was the governor's witness, and Dr. Dilution provided, I think, a pretty good testimony, most of which I think is referenced in Judge McCullough's report. At paragraph 51, Judge McCullough accepted as credible Dr. Dilution's opinion to the extent she concluded, among other submissions, that the map of the voters of PA, Amici, who you'll hear from later today with Attorney Gallagher, and Reschenthaler 1, both evince a first-tier standard of excellence and easily satisfy the baseline floor, standard, or neutral criteria under League of Women Voters 2.
Mr. King, first of all, your 2 minutes are up, so anybody should feel free to ask questions. But second, you have limited time. I'm a little surprised. You're not touting your own map?
Well, I just wanted to, I want to get to my map and tell you why my map is a good map.
I don't want your map to end up on the cutting room floor as we consider your arguments on other maps. So I'd caution you to tell us why your map's good. But it's your argument. If you want to argue on behalf of the McCollum map, that's your choice.
Well, if you don't mind, Your Honor, I'll try to speed through this. But looking at Judge McCullough's report, she also concluded at paragraph 54 that Reschenthaler 1 and 2, according to Dr. Dilution, put together the lowest county pieces and lowest municipal splits. Our map was almost equal to Reschenthaler 1. We had the second fewest number of county splits, and we had a very low number of municipal splits. This map, as you can see, was designed for the purpose of primarily addressing all of the constitutional questions, but in particular, the municipal and county splits. We considered that the county splits, I think I heard earlier Mr. Haverstick address the court, addressing a question that was posed to him about which one of these were more important, boroughs, townships, cities, and incorporated towns. I agree with what I think I heard was the conclusion that counties would be the most significant entity that would need to not be split. And so our map, which is before you, you'll see that we had applicants in this particular matter from Butler County, and you'll see that for a change, all of Butler County is incorporated into one congressional district. In the 2018 map, Butler County was split into 3 districts. And you also see that we have Cambria County, which in the past has been split a number of times. You'll also see that we include all of Washington County in one congressional district. We also have all of Center County. We also have all of York County. We couldn't avoid some split in Cumberland, although we had people from Cumberland in our group. We also have all of Tioga County, and we did have to split Luzerne. But with respect to the constitutional requirements of avoiding the splits of these municipalities, that was the goal of this map. And I think that we accomplished that to a great degree. And so, again, I want to say that we believe that our map evidences partisan fairness. There were 3 experts that addressed our map, one of whom said that it had a slight Democratic advantage, 2 of whom said that it had a slight Republican advantage.
Although in that respect, Mr. King, the Gressman scientists, who at least facially appear not to be biased for one or the other political parties, I think said that you had a significant Republican bias to your map. Is that my recall accurate?
I think they may have said that about us, but that's not what other experts said. And of course,
that's just not so?
Pardon?
You think that is just not so?
I think that it may have a slight Republican bias. 2 of the 3 experts said that, but one of the experts said that it had a slight Democratic bias. And so our attempt was not to introduce bias into this. We didn't, like the Gressman group, we didn't have an algorithm that would try to produce a certain result. And for that, I'm critical of the Gressman analysis, because if you think about it, in today's world, telling the voters of Pennsylvania that you have somehow introduced an algorithm that will produce a certain result is going to call into question not only the people that developed that map and what the algorithm was, but whether or not someone is trying to get the Supreme Court of Pennsylvania to recognize that an algorithm that produces a certain result can be a factor before this court.
Counsel,
I don't think it...
Counsel, we're talking about political bias. I noticed your map happened to be one of the only ones that had paired incumbents, and they all happened to be 4 Democrats, 2 of which eventually retired or is now running for another office. How are we to accept your proposition that it might be Republican leaning when the entire scope of your map wants to remove, in the Philadelphia area, we have Madeline Dean, you have Scanlon from our area, you have Matt Cartwright from the northeast. And there is the potential of Mr. Mauser as the only Republican, but I find that somewhat disingenuous. Explain that to me, how you're saying it may have a Republican lean when your entire map is centered to remove Democrats.
Well, Your Honor, of course, one of those two contests would pit one Republican against one Democrat. The other one down in the...
That would be Kevin Boyle versus Fitzpatrick, correct?
No, it would be in the Northeast. We would pit Representative Cartwright against Representative Keller. And so I've seen the analysis that apparently Representative Houlihan and Representative Dean may end up in the same district. We had some difficulty identifying exactly where Representative Dean resided. So I would say that I will assume that that's correct. But it was not our objective to attempt to get those two in the same district.
But with regard to Mr. Cartwright, you removed the areas based upon the 2018 election and permitted him to accept a broader swath of geographically established Republican, yes?
Well, I can't agree with you precisely, but I understand your point, Your Honor. And certainly we did revise the Cartwright district. There were a couple different ways to go, and some of the maps that have been presented here pit Representative Cartwright against Representative Muser, using the southern portion of the district to include up into the Wilkes-Barre-Scranton area. So, yes, Your Honor, you're correct that there are two contests.
And lastly, correct me if I'm wrong, in your presentation, there was no expert provided on this record to support your argument that you're making right now.
That's correct, Your Honor. We were granted amici status, and the order that came down said we could file a brief or an expert report. So we filed a brief, and I will tell you that reading through and watching the proceedings, the experts analyzed our map as well as the others, and so some of what I've said here today is the result of that analysis that was provided by the experts, including the governor's expert, who I thought did a pretty fair job at analyzing our map and others. She actually points to the Reschenthaler map and the voters of PA maps as first tier. That's pretty high praise coming from the governor's expert. I did want to address, yes, sir.
Just on the incumbent pairing, since we're on that topic. Governor's Wolf map pits Dean against Scanlon too, doesn't it?
I'm sorry, Your Honor.
Governor Wolf's map, doesn't that also pit sitting Congresswoman Dean against sitting Congresswoman Scanlon?
Yes, sir, it did.
So it's not, your map's not an outlier in pitting Democrats against each other?
Yes, Your Honor. We're not the only ones.
It would be the outlier in that it's only pitting Democrats without Republicans, as opposed to Governor Wolf, which is predominantly pro-Democrat. Fair?
It's fair. I would find it foolhardy to come in here and pit only Democrats against Democrats. So I would hope that we would never do that.
Well, I think Justice Doherty just suggested you did, if I didn't misunderstand it. Tell us on your map where you have a Republican running against a Republican, or a Republican incumbent who's been not using it in a prejudicial way, but moved, I'm not going to use the word gerrymander, moved into a district where his result is in doubt.
Well, I understand your point, Your Honor.
I'm only asking.
Yes, sir. Well, in the northeastern part of Pennsylvania, it was necessary when we were drafting these maps. It appeared to us necessary that two people were going to get combined into one at some point up in the northeast corner. And it was either going to be Representative Cartwright, because that's where he is. It was either going to be a Republican by the name of Keller, Representative Keller, or it was going to be Representative Dan Muser, one of the others. So that's what a fair map looked like to us, pitting those two against each other. And there's certainly no given result. There's no certain result with respect to that pairing either.
Fair enough.
I did want to say,
we're not for D's or R's, but we're trying to come up with a fair map.
Your Honor, I grant you that, and certainly you have a very difficult task. It's not one that the court had anything to do with in terms of generating it. So,
And thank you for appreciating that. We'd rather not be here also, but.
Yes, Your Honor.
Back to District 8. That's designed so that the Republican advantage there is such that it would be darn near impossible for even a well-liked candidate like Cartwright to win that district. Isn't that indeed the fact?
I will grant you that I personally think that either of the two Republican candidates will be strong, but Representative Cartwright's been in Congress for a number of years. He's well known in that area, and he's been very popular. So I don't know what the end result would be, but he's certainly a strong candidate. I did want to comment, and I also wanted to say that we kept Pittsburgh intact, and I'm aware of the makeup of the court, and I'm a Western Pennsylvania myself, so I heard.
You heard one of the council accuse me of being a Pittsburgher when you know I'm from Butler County.
Yes, ma'am.
All right.
We're proud of it, so, and thank you.
Except for your period of proud residency in the
past.
In the past.
I think you've also claimed Lawrence County, if I'm not mistaken, too, Your Honor.
I claim multiple counties. Yeah.
I'm of that bent myself when it suits. So I wanted to say for those Pittsburghers who are here, I took a look at this because I thought that I just thought it was absolutely wrong, the cracking of Pittsburgh, the splitting of Pittsburgh, and so. I know that everybody on this court's been to Pittsburgh and knows Pittsburgh, but not like the Chief Justice and the others in this court know Pittsburgh. And so I looked at, for example, Governor Wolf's split of Pittsburgh. What are we splitting if we split on Governor Wolf? We use Governor Wolf's map. In District 16, we would include Mount Washington. We would also include Beachview, Elliott, Perry North, Perry South, Duquesne Heights, the South Shore, and Carrick. And in a different congressional district, we would have the Strip District, Greenfield, Squirrel Hill North and South, Point Breeze, and Shady Side, Oakland, Bloomfield, Bluff, and Middle Hill. It doesn't seem logical to me as an almost Pittsburgher. I live just outside of Pittsburgh in Butler County. It doesn't seem logical to me that those districts would be represented by different congressmen. The Senate Democratic Caucus 1 map of Pittsburgh split includes in their District 12 the Central Business District, the Strip District, Bluff, Middle Hill, Terrace Village, Squirrel Hill North and South, Point Breeze, Shady Side, Garfield, and East Liberty, while the 17th includes Hazelwood, Glen Hazel, Greenfield, New Homestead, Lincoln Place, Hayes, Mount Washington, again, I emphasize that because everybody knows about Mount Washington, I suspect, as well as Manchester and parts of Brighton Heights and Perry North. The Draw the Lines map includes a 15th district, which includes the Central Business District, the Strip District, Middle Hill, Terrace Village, Squirrel Hill North and South, Shady Side, Lawrenceville, Glen Haven, and in the 17th district, they've included Troy Hill, North Shore, Perry North and South, Brighton Heights, Marshall Shadeland, Crafton Heights, Elliott, Duquesne Heights, Beachview, and Westwood.
Council, can we talk about your map? Where is Fox Chapel Borough? Is it in your District 16 or District 9? Is it in your district? I can't read the number from here.
Yes,
District 16. Is it in District 16?
I can't honestly say, Your Honor. I don't recall exactly which one Fox Chapel is in, but from
You have it in 16.
And so my question is, what's the logic of pairing Fox Chapel Borough with far north, southwestern Mercer County? I mean, I understand the analysis you're going through borough by borough, township by township in Allegheny, but I don't see if what you're talking about community of interest between Fox Chapel Borough and anything in Mercer County.
Well, I don't think that that district that we show, I don't think it's really dissimilar to a great extent from the current Connor Lamb district. It's very similar, where it's Sewickley and those communities are included in the Connor Lamb district, which tilts Democratic.
But Sewickley isn't in Mercer County.
Well, yes, in order to equalize the population, we had to we did. We had to go into the southeast, or southwest rather, corner of Mercer
Allegheny
County.
County had to be cut. That was your effort to fairly cut it.
Yes.
Yeah. I think we've consumed 15 minutes. If nobody else has any questions, why don't you take a minute and sum up?
In summary, Your Honor, the map that we presented, I think, is got pretty good grades, pretty good marks. I think it's a fair map. I do, and I think it's one that would meet all of the core constitutional requirements for adoption. We did say in our brief, and I do want to add that if the court chooses another map, we believe that Reschenthaler 1 or the PA voters which were given first-tier status by the governor's expert witness, would be alternatives to our map. But I do think our map is a good one. I think it respects community boundaries, it respects county boundaries, and it's one that meets all of the core requirements of the Constitution. So I thank the court for your time, and it's my pleasure to be here. Thank you.
Thank you very much.
Yes, sir.
All right, we'll next hear from Draw the Lines, PA, which is Mr. Lavelle.
Good afternoon, and may it please the court. John Lavelle from Morgan Lewis for the Draw the Lines Pennsylvania amicus participants. Although they're not here with us today, I want to thank and recognize my colleagues from Morgan Lewis from our Pittsburgh and Philadelphia offices, as well as elsewhere around the country, who work with me on this matter and did terrific work on it. The plan proposed by the Draw the Lines participants, known as the Citizens Map, is the product of unprecedented and extensive public participation. The map we've presented is not a map drawn by elected officials or a political party. Rather, it's a map that reflects the input of over 7,000 Pennsylvania citizen mappers. The map produced by these citizen mappers produces scores at or near the top of every metric and reflects the priorities of everyday Pennsylvania citizens. It's a map that's worthy of consideration for adoption by this court.
Yeah, and we complimented the people that did the Gressman map, the scientists. I thought the committee of 70 and the methodology used here was really commendable. So sort of regardless of how we turn out here, congratulations to all those involved in a really transparent process.
Thank you, Mr. Chief Justice. Really appreciate that. And if I may, I'd like to address 2 points today. And first, I would like to give a little more detail about the unique way in which this map was created, and then turn to why the Citizens Map, considering both the neutral constitutional criteria as well as partisan fairness, is a superior map. It should be adopted. So the Draw the Lines Pennsylvania map started with the Committee of 70, the Pennsylvania's oldest and largest nonpartisan good government group, starting this program. And we had participants, over 7,000 Pennsylvania citizens, representing 40 out of the 67 counties and 90% of the population. They drew 1,500 congressional maps in a series of competitions over a period of several months. Those maps were then drawn and scored, and their statistical averages were used by a citizen map corps of 40 citizens to develop a citizens map. Then that map was provided, it was posted and made public, and public comments were solicited. And we received over 100 different public comments, which were very helpful. And as I'll discuss on a few key points, really helped us revise and shape that citizens map. So the final map that was produced here reflects tremendous input from ordinary citizens and really reflects what ordinary Pennsylvania citizens declare to be important to them. So turning now to the map, considering the neutral constitutional criteria as well as partisan fairness considerations, we have a superior map for the court's consideration. The neutral criteria that are defined in the League of Women Voters, this map produces at the top on all of them. The total deviation is only one person. Contiguous, in terms of compactness, it's at or near the top of all those metrics. In terms of jurisdictional splits, it's a top performer. It's depending on how you count the jurisdictional splits. It's either tied with the Gressman map or just behind it. And I want to just correct a mistake that we had in our submission to the court. We would say that we would defer to Dr. DeFord's numbers in terms of the splits. His numbers are correct. So if you count the municipalities that span 2 counties, we have slightly more splits than the Gressman map. We have 52 as opposed to 49. If you don't count those municipalities that span 2 counties, we each have 46 splits. So it's a low number of county splits and so on. The result, that's total splits. Counties, municipalities, wards, everything.
49, am I correct?
Correct, 49. That's 49 for Gressman, 52 for us.
And yet, if I could jump in.
Yes.
You basically just draw a line down the middle of Allegheny County bisecting the city of Pittsburgh. Why did you have to do that? Why did you have to divide the city of Pittsburgh? It hasn't been done since, 82, when we had 4 congressmen in Allegheny County?
Yes, Justice Weck,
Actually, 72.
72?
I agree that it has been a while since the city of Pittsburgh has been split into 2 districts. There are reasons why we did it based on the input from the citizens here. We start from the idea that Allegheny County has to be split, right? Because of the population.
Pittsburgh is only about a quarter.
Correct. So either you keep it all together and then you have to divide up and it has a ripple effect on everything else. So when we solicited input from our mappers, we found that they wanted, for example, a clean line of demarcation between Beaver County and Washington County. They wanted Butler County in a district with Erie. So many of the mappers ended up focusing on the rivers, the natural border of the rivers, as an appropriate place to draw the lines.
What about the community of interest, though, in the city of Pittsburgh? I mean, I'll ask you what I've asked other counsel today. Why was it absolutely necessary to split Pittsburgh into 2 parts?
So 2 things. First, we had the input from these citizen mappers who, a plurality of them, including people from Pittsburgh and from Allegheny County, that was the way that they preferred to see the maps drawn. And then the other point is that there's going to have to be a split of Allegheny County with 0 population. So
But why Pittsburgh?
either you're going to end up splitting smaller municipalities or you're going to split the city of Pittsburgh. The 2018 map that was prepared by this court, that was adopted by this court, had 2 municipal splits. They were smaller municipalities. So the reasoning was split the larger municipality to keep commonality of interests in that larger group rather than crack the smaller municipalities.
What I was going to suggest to you, and you may not be able to answer it, is that it was a flawed premise to use rivers to divide entities, because the truth is, historically, cities grow up around rivers. Pittsburgh grew from the Point, I mean, not to get overly esoteric, but Buddha's on one side and Pesta's on the hill on the other side. You know, you go to Harrisburg, and the Susquehanna River, I mean, where we're sitting, has Camp Hill on one side and has the city of Harrisburg on the other side. So to use rivers almost guarantees the division of communities of interest.
The other thing I would say, Mr. Chief Justice, is that we wanted to avoid a split of Washington County. We wanted to avoid a split of Lawrence County. To keep those together and to try to achieve the other lines, avoiding a split of Beaver, keeping it together with other counties. That's how we ended up there.
I just want to jump in and say this, and then I'll stop on this. Is it to regard maintaining the county lines of Washington or Beaver or whatever other county you just mentioned as holy writ, and yet dividing the south side of Pittsburgh from the Allentown section of Pittsburgh, that's the height of arbitrariness. I mean, it makes no sense. I mean,
it's even more strained, I think, than the Wolf and Costa maps we talked about earlier. Because what you've done is you've basically bisected the hilltop neighborhoods on the south side of Pittsburgh. There's no, I can't see anything in your papers to substantiate the choices made by your map maker.
Justice Wecht, I would say that this was a topic that we spent a lot of time with the citizen mappers on, and we did have a number of people from Pittsburgh as well as Allegheny who debated these issues vigorously. We did have people who were involved in this process who wanted very much to keep the city as a single district, but the majority of our group, and really in terms of working out what the ripple effect would be on the rest of the western part of the state, that's where we ended up, and we think that it is an appropriate way to divide the line.
And Mr. LaBelle, hindsight's always 20/20. You chose, in good faith, in fairness to you, to use county lines and to keep counties intact, and that caused some cities to split, and it's too late to redo it until 10 years from now. So,
Mr. Chief Justice, I would not disagree. We tried to minimize county splits, and that does have consequences. Some of the other maps that have been presented to the court, while they have pretty close numbers to us in terms of counties, they have many higher splits of municipalities, many higher splits of wards in individual divisions. So you've got a ward where people on one side of the street are going to one district and the other going to another district. If I could turn to an issue that I know that Justice Brobson had raised earlier, that is the treatment of Dauphin County. I think it's a good example of the way the citizens map process worked, because the first iteration of our map had Dauphin County split and combined it with parts of Bedford and Blair County. We got overwhelmingly negative response to that from our Dauphin County participants. They said, you've got to keep Dauphin County together. So we redid the map.
I don't know if you need to be keeping it together, but I can imagine they said, why are you putting us with Blair and Huntington County?
Correct. So the map that we've submitted to the court for consideration has Dauphin and the western half of York County together in a single district. And I think that reflected helpful and important input from citizens who lived in the area as to what was important to them and where they believed that they had a commonality of interest.
Can I ask you about incumbent pairings, since that's come up a little bit? The map pairs an incumbent Republican against an incumbent Republican, and then pairs a incumbent Democrat against an incumbent Republican down down in the Southeast. Why were those decisions made?
We were reflecting the input from our citizen mappers, and they valued competitive districts, and they thought protection of incumbents was less important. So, for example, on competitiveness, our map would yield 6 strongly Republican districts, 5 strongly Democratic districts, and 6 competitive districts. That is, 6 districts where party candidates would be expected to be within 10% of one another. And that is, I think, really at the top. Only the Gressman map is close to our map in terms of competitiveness in that
Of
realm.
those 6 swing, how many lean to which side?
I'm sorry, Justice, I don't have the answer to that question. I can try to find that for you. But I think that the idea would be that this would make 6 competitive districts that would be, overall, our plan in terms of partisan fairness has a plan score that is a efficiency gap of 3.5% in favor of Republicans. Now that is very...
Are there any minority, majority districts? I apologize. There's so much information here.
Yes, we have 2 majority-minority districts in the city of Philadelphia. And so we would have an efficiency gap of 3.5% in favor of Republicans, which is very comparable to what the map that was adopted in 2018 is. I will point out that, as Dr. Dilution pointed out, that the way that our map is structured, it overcomes a structural tilt towards Republicans and makes the map more even-handed. And we were recognized in her report for leveling the partisanness of the playing field.
And you believe that it's this court's job to tweak a map to change what exists naturally?
I would not put it that way, Justice Robson. I would say that structuring the map in a way that is structured for partisan fairness, and that is reflecting what would overall be expected to occur, and that produces a large number of competitive districts, is absolutely important. I think that's what our citizen mappers recognize, and I think that voters would like to have a say in who they're, who's representing them. You know,
So maybe I've missed something, and forgive me if I have, but the 10% number that you used as a frame of reference for a district being competitive, where did that come from?
I believe I'm citing the DeFord rebuttal, table 11, and I think we've defined this in terms of number of districts that consistently vote in favor of either party, and that's where we get that 10% figure from.
Okay.
Historical.
And are you familiar with Dave's redistricting at all?
Yes.
Okay. Do you find it credible, reliable?
I've used it. I know our citizen mappers have used it, yes.
And how many swing districts did you say are in your map?
6.
Okay. And if I told you that under Dave's redistricting, 5 of the 6 swing districts lean Democrat, would you have any reason to question that?
I wouldn't be able to say one way or another, Justice Robson.
Now that you're done being cross-examined, do you know the parameters of Dave's redistricting at all as to what they call leaning one way or another? Do you know what that means? I mean, what percentage does that encompass when Dave's redistricting says leans one way or another?
I don't know what Dave's redistricting means when they say that. So I've used the tools on Dave's redistricting, but not that particular tool. So that's a part of it that I know it's a very deep and powerful tool, but that's one aspect of it I have not used.
Do we know who Dave is?
I don't know. I wish he were here today. I'd have him sitting at council table with me.
Dave's redistricting sounds kind of like an ice cream stand.
Mr. Lavelle, your 15 minutes are up. Why don't you take a minute or two and sum up anything you'd like to make more coherent?
Thank you, Mr. Chief Justice. While there's no single perfect map, the citizens map meets the constitutional neutral criteria exceptionally well and achieves superior balance, competitiveness, and proportionality. It's not a map that was drawn for partisan advantage. Rather, it reflects the values and judgments of ordinary Pennsylvania citizens who embrace the challenge and the opportunity of proposing a fair and balanced map. The citizens map is worthy of consideration and adoption by this court. Thank you.
Thank you.
Thank you very much. Well done. With good humor. Next, we have amicus Khalif Ali, represented by Mr. Geffen.
Good afternoon, and may it please the court. My name is Ben Geffen. I'm from the Public Interest Law Center in Philadelphia. I'm joined today by my boss, Mimi McKenzie, and would also like to recognize with great gratitude the assistance of our co-counsel Suzanne Almeida from Common Cause, as well as Marty Black and Andrew Rocco from Deckard. I'd like to begin by just...
Before you begin, I just can't resist. I spent the first 5 or 10 years of my life torturing and being tortured by Pilcop. I didn't know it was still in business. No prejudice at all. Go right ahead. I worked for the Pennsylvania Department of Justice, the forerunner to the Attorney General.
I think I see what you're driving at there, Your Honor, in terms of our cases at that time.
Deja vu. Go right ahead.
So I'd like to begin just by briefly describing our clients in this matter. They are Democrats, they are Republicans, in one case a non-affiliated voter, and they're all leaders or involved with organizations that are committed to fair districting, including Common Cause, the League of Women Voters of Pennsylvania, and Fair Districts Pennsylvania. There are numerous excellent plans in the record. We believe that the Ali plan is the best of the bunch and should be selected. And I'd like to briefly explain how the Ali plan was crafted. We started with the plan that was submitted by Governor Wolf, which we believe to be a good plan, both in terms of the way it looks and also in terms of the way it was made. He disclosed principles used to develop the map and relied on extensive public input in drafting it. But we thought it could be made better. And so we made a couple of different types of changes. We began by using the same data set for addresses that the LRC has used to craft state legislative plans. And ours is the only plan before the court today drawn on that basis. And this necessitated some adjustments, particularly in the city of Philadelphia, which gained over 7,000 residents as a result of this adjustment. And then the second change we made had to do with communities of interest. We looked at bodies of evidence about communities of interest, including extensive testimony submitted to the LRC from individual citizens, as well as hearings held by the governor and by the General Assembly around the state. And the two most important changes we made were one in the Pittsburgh area and then two in the Capital Region. And specifically in the Capital Region, our map differs from the governor's map by keeping Harrisburg and its suburbs together. We also made minor adjustments in Philadelphia, including not using North Broad Street as a division, but ensuring that all of the Temple University area is kept into a single district. And one thing we didn't do, or two things we didn't do, we did not consult partisan data when crafting the map. That's something we looked at only as a sanity check after completing it. And we also did not consult incumbent addresses. It's our position that consideration of where incumbents reside or may be paired is not something that should be considered in the crafting of one of these maps.
Council, what was the purpose of preserving the Temple area of North Philadelphia?
That was driven by comments that were made by Temple University students that their district had historically been divided and that it made sense for all of the new voters at Temple University to have the chance to be grouped together into a district.
At the expense of Northeast Philadelphia and South Philadelphia residents, long-time, generational residents?
Well, Your Honor, respectfully, it was a relatively minor adjustment that was made to the map. It was a matter of jogging a line over by a few blocks and then back down to join North Broad Street again.
So I apologize. You're going from, instead of North Broad Street, you're doing what?
Just jogging a few blocks over to group all of the Temple campus together instead of, because Broad Street is, Temple, I think there was a mention that, of Buddha and Pest developing along both sides of a river. Well, the Temple campus is also developed along both sides of Broad Street. And the idea was that keeping it intact into a single district would respond to statements made by some folks who were part of that community.
So a statement made by a transient student for a 10-year plan trumps the position of a lifelong South Philadelphia and the Northeast resident. That's what you're telling us, that you're asking us to accept as the basis for this plan?
Your Honor, the people living within the Temple University campus may change over a 10-year period, but at each election there will be a community there consisting of Temple students, many of whom are engaging in voting for the very first time in their lives.
So is that a yes? You're putting the transient Temple first-time voter, their desires over a lifelong generational resident of the other ends of Philadelphia, primarily Northeast, which you're moving in from Brendan Boyle to Fitzpatrick, and the South Philadelphia area, where you're now competing two congressional Democratic representatives, I believe, Madeline Dean versus Scanlon.
Well, and to turn to that point, Your Honor, we did not take into account the residences of incumbents when crafting the maps. And I would also like to note that none of the parties, to my knowledge, in this litigation, considered the residences of challengers. And we believe that's appropriate. We don't think it would make sense to look at where the challengers live in deciding where to draw congressional districts. We did not draw the districts based on where any other candidates, including sitting office holders, lived.
But counsel, given that the signature period is subsequent to our activities, who knows who the challengers are?
Certainly, Your Honor. Some people have announced an intent to challenge, but there will be more, to be sure.
Could I ask you a question, counsel, on a different aspect of yours? I'm interested in knowing whether you think there's a constitutional issue in either direction in the event that the LRC plan were to be adopted, whether in whole or in part, taking into account those prisoners addressed with the prison residents, that subset of the prisoners addressed that way. In the event that the court were to choose a congressional map that did not treat the prisoner residents in the identical fashion, would there be a constitutional issue in any direction?
No, Your Honor. I don't believe that would create any constitutional problems, nor is our position at this juncture that the court is compelled to use the prisoner-adjusted data for drawing congressional districts. We believe, however, that there are good policy reasons as well as legal reasons to do so, and that consistency with the LRC map would be a virtue. These are all plus factors in favor of doing it, but none of them is a make-or-break constitutional issue.
And suppose that the court agreed with your plan, but for the prisoner issue. How would the court go about making those adjustments without the benefit of hiring an expert on its own in time for the May 17 date to hold?
Your Honor, I believe the assistance of an expert would be required. We were allowed to submit but one plan in the Commonwealth Court proceedings, and so we were did not have the opportunity to submit a second plan that did not include that allocation. One thing I would also add about the prisoner adjustments is that, part of its significance is that it moves people from certain counties to others. And so just to give a couple of examples, Somerset County is home to 2 SCIs, home to over 2,300 people according to the LRC dataset 1. And this inflates the population of a county like Somerset as well as Clearfield or Forest County, and that gives them an outsized presence within a single congressional district. And we believe that Pennsylvania, it's time for Pennsylvania to join the at least 7 and growing number of other states that are redrawing congressional districts this year on the basis of adjusted prisoner addresses. One other point I would like to make is that
Please make your point, absolutely, and try to give us your most important points in conclusion, because I think we understand your argument.
Thank you, Your Honor. I just wanted to address something that has scarcely come up today, which is a flaw in the decision or the recommendation by the special master. That decision was predicated in part on a legal conclusion that that the House bill deserved some degree of deference because it was passed by the General Assembly. As we detail in our brief, this is a conclusion that has been rejected repeatedly by the U.S. Supreme Court and by this court. And I would just emphasize that the Smiley decision of the U.S. Supreme Court makes it a question of state law. Who has the lawmaking power under the Elections Clause of the U.S. Constitution? The term the legislature is used in the Elections Clause means the lawmaking power of the state, according to Smiley, and whether the governor has a role in the lawmaking power, quote, is a matter of state polity. This court has said in numerous decisions cited in our brief that the lawmaking power involves a role in this state for both the General Assembly and the governor. This would be an opportunity in a congressional redistricting case for the court to clarify how Pennsylvania state law interacts with Smiley v. Home and to once and for all put to bed the notion that the General Assembly has a special role vis-a-vis the governor in congressional redistricting.
Thank you. Thank you very much.
Thank you, Your Honor.
Segue into the Senate.
Yeah, it really is. Just as Todd just said, and I concur, it's a nice segue into the Senate. Republican interveners who will argue next through Mr. Holtzman.
Good afternoon, Mr. Chief Justice and other members of the court. May it please the court, my name is Anthony Holtzman, and I represent the Senate Republican interveners, namely Jake Corman, the President pro tempore of the Pennsylvania Senate, along with Kim Ward, the Majority Leader of the Pennsylvania Senate. My co-counsel, Craig Wilson and John Vadel, weren't able to join me here today, but I'll introduce them despite the fact that they're not here with me.
You rewarded them by not telling them to come.
I think that's probably true, Your Honor. So in an impasse lawsuit like this one, when multiple proposed congressional redistricting maps meet the traditional redistricting criteria, the court must necessarily look beyond those criteria or look for something else in order to pick a map. And in this case, when you look beyond those traditional criteria, you see that there are certain important things that have occurred with regard to HB 2146 and certain important things that have not occurred with regard to HB 2146, and that taken together, these variables show that the special master was correct in recommending that this court adopt HB 2146.
Whether or not that is true, can you agree, can we agree that there is no deference owed to the House plan because it wasn't enacted, because it was vetoed by the governor? It's entitled to no more deference than the governor's plan or any of these other plans. It's entitled to thoughtful consideration but not deference?
I think I'd frame it differently than deference to Your Honor. I'd say it's singular in a certain respect. It stands out, and I'll explain if I could. It's the only proposed redistricting map that's been subject to the sort of public input process that it went through. It's true, as you said, that the Pennsylvania Senate and the House passed the bill and ultimately the governor vetoed it. But along the way, HB 2146 was made available for public comment. It engendered 399 public comments, prompting the bill to be amended in certain ways. And although, as I said, the governor ultimately vetoed the bill, the other parties in amici's plan didn't go through that sort of public process.
That's a good point.
And so,
May I ask you in that regard, and this may be outside the record, and if you can't answer it, I respect that very much, but if it's in the record or if you know, was there an attempt at bipartisanship? Was there an attempt to negotiate this with Democratic legislators?
my understanding at a high level, Your Honor, is that there was, and I don't know the details beyond that.
Fair enough.
And stipulate that failed.
At a high level, and you know, the General Assembly, there were members of the General Assembly, of course, in the Democratic Party in the Senate and in the House. They could have, of course, participated in the process. They could have circulated their own co-sponsorship memos for proposed plans. They didn't do that. They could have introduced their own bills that embodied proposed.
I think you know, if we start going that route down, what could have happened, we could be here for a while. The problem is we're here and we have to do this. But you know, everything I learned about social studies, I learned on Schoolhouse Rock, and you know, I'm just a bill. You know, it's just a bill. It didn't become a law. I appreciate the fact that it represents the will of the majority of elected, pretty much Republicans of the General Assembly, which has the majority. But I struggle with Judge McCullough's articulation that somehow, some way, that represents the will and the voice of the people, and that Governor Wolf's veto also doesn't represent the will and the voice of the people.
Well, again, Justice Robson, maybe I should clarify a little bit. My understanding at a high level was there were members in the Republican Party in the General Assembly who reached out and tried to work on a measure that would potentially be a compromise solution. But beyond that, I think what distinguishes this from a situation that might otherwise exist is that, and what I was about to say and what I was driving at, is that the Senate and House Democrats and the governor did not meaningfully participate in the public process of enactment of this bill at all. And so in a situation where there had been material negotiations and engagement between the different entities.
Does any of that matter? Let's assume you're correct, and I'm not sure that you are correct, but let's assume that you're correct. Does it matter? Does that even help us? Does that help us in this process?
But I think it gets to what you were driving at before, Justice Robson, which is to say that the Republican members of the General Assembly did try to go through the process and not have this thing end up in front of the court, right? And if the other political branches didn't participate and didn't engage and didn't actively attempt to reach a compromise position.
But what does that, let's say that's true. Again, what does that get you? I don't understand. Does that mean because they didn't participate, we should give the bill that was passed deference? I don't understand why this has anything to do with the deference issue. It gets to the issue of gridlock. It gets to the issue of nonpartisanship. But it doesn't get to the issue of which map we should choose.
In other words, instead of the argument from authority, is there an argument from reason or metrics or what have you.
It's the process, I think, that I'm driving at. That this bill had a...
You're not arguing for deference, are you?
Yeah,
It's not deference per se, if I could, sorry, Your Honor, I didn't
I
mean to
think
cut you
I
off.
got you off track. I apologize.
No, it's-
To get this back on track in deference, the question that Justice Todd, I think, started this whole thing with is, was Judge McCullough correct in providing deference? I think you said no, and then you digressed that it has some special status, unusual status, but not rising to deference. If you want to add to that, feel free, and I think that takes care of this area of inquiry.
That's right, Your Honor, and if, maybe I'll try to articulate it a little more cleanly. I don't know if I'll be able to do so, but there was an effort to have this bill go through a public process. There was a public input process here, and the other political actors didn't put their bills through a political input process, and they didn't attempt to engage in a legislative process. So that bill stands out for this reason.
Can I interject there? My understanding is that the governor had a very robust website and accepted input from thousands of people in Pennsylvania in the context of that website. Whether or not you consider that to be the same kind of process or not, and frankly, I don't know where this gets us, because, I mean, I think we are all in agreement that neither of those two plans deserve any deference. But, you know, I mean, for us to politicize this or take partisan sides in this is really a non-starter in this context. I'm here with multiple maps before us that I think stand on equal footing. So.
No, thank you, Justice Donahue, and you're correct, there was that website, but just the governor did not release, sort of for public review and consumption, his proposed map until January 15th, as noted in his brief at page 4.
But supposing, counsel, just
Yep.
supposing, arguendo, that the court declines to elevate 2146 over the other maps by reason of anything, and chooses instead to view all the maps on a level playing field, do you have arguments for us on why the map you favor is the one we should choose?
Yes, thank you, Justice Wecht. There are things that have not, I said there at the outset, there are things that have not occurred with regard to HB 2146. That's sort of the way I think about this. One of those is that during the hearing in this matter, nobody showed that HB 2146 is out of compliance with any of the traditional redistricting criteria. And I think we all agree that, you know, for the most part, the maps that are before the court meet those criteria. So that's one thing that didn't occur. That is to say, nobody made that sort of a showing at the hearing. Another thing is that during the hearing, the bill was not shown, and this is sort of a related point or a corollary, was not shown to split political subdivisions, even though doing so was not necessary to achieve population equality. And we've had some discussion today, of course, about Pittsburgh, right? And I think something that's kind of gotten lost in the shuffle a little bit as we talk about Pittsburgh is that there's an evidentiary record here in this case. It was created by the special master. And at that hearing, evidence was presented that Pittsburgh didn't need to be split in order to preserve population equality, or for that matter, to preserve a community of interest. So that's what's on the record. And a lot of this discussion about why other splits occurred, why they didn't occur, there's no record of any of that. And when it comes to HB 2146, the only record that exists is the legislative history, right, for the bill. And so at the hearing in this matter, there was evidence presented that the judge found credible that there was no need to split the city of Pittsburgh in order to maintain population equality as between districts. And so that's why it has become a big issue in part, and also it's the second largest city in the Commonwealth.
Instead of Pittsburgh, let me ask you about Philly. You split 5 Philadelphia wards and create a situation where there are 4 different members of Congress representing the city of Philadelphia. I didn't see any evidentiary basis, or could you explain why you did those splits, why that is in the best interest of all these metrics?
And Justice Weck, I'm not trying to be evasive at all, but I don't know that I can say that without referring to the legislative history of the bill, because I can't project here what the wishes are of the members of the General Assembly who adopted. I don't know that there's anything in the legislative record that addresses those I could be wrong, but I can't recall that there's anything in the record that addresses those particular issues and explains why they may or may not have occurred.
We've been asking a lot of questions about splits today, and I guess the question is, in the record, did anyone on cross-examination of an expert or anything like that I know there's a lot of questions about the city of Pittsburgh. There's a lot in the record about the city of Pittsburgh.
Yep.
Did anybody question any other split, any other county split, any other municipal split in the way that they really focused on Pittsburgh?
Not to the same extent. There was some discussion about, Your Honor, if I could just make sure that I get it correct. It was another section, it was another area of the state near Philadelphia and combining it with or without parts of Bucks County. But other than those two instances, there was no other record evidence about splits and why they may or may not have been necessary. And I think that's a point that I really did want to emphasize today, is that this court shouldn't make findings of fact in a vacuum without an evidentiary record. And there is a record on Pittsburgh and the other split that it's escaping me exactly how it was defined, but it had to do with, it was in the Philadelphia area and combining sort of the surplus Philadelphia population, Philadelphia, of course, needing to be split.
Was it the split of Bucks County?
I think it was, Your Honor, and whether it made sense to, or whether, from a preservation of communities of interest perspective, it made sense to combine the surplus population with southern Bucks County or not, or Montgomery County. So there was evidence at the hearing on that as well. But apart from that, and that drives to a point I wanted to make, which is there was no evidence that any splits emanating from HB 2146 were unnecessary, either in terms of population equality perspective or in terms of preserving communities of interest. And so that's another thing that didn't happen, if you will, with regard to HB 2146. There was no such showing during the evidentiary hearing. And despite the fact that, as you heard, that HB 2146 didn't divide Pittsburgh, a number of the other maps before the court did. Another thing that has not occurred with regard to HB 2146 is that during the hearing, nobody showed that the bill was crafted in a way that, despite complying with traditional criteria, was somehow designed or intended to benefit or enhance one political party against the other one. And so that's another thing that didn't happen at the hearing. And certain other plans were addressed at the hearing in that regard, but HB 2146 was not one of them. And the one other thing I really want to emphasize, if I could, about HB 2146, another thing that didn't happen, is that during the hearing, nobody demonstrated that despite complying with the traditional criteria and despite not having been shown to have been drawn in any sort of nefarious way designed to elevate one political party's prospects relative to the other one, nobody showed that it was nonetheless insufficiently fair. We've been talking about that all day. There was no showing that whatever insufficient unfairness means that we crossed that line. There was no such showing, and I think the justices have acknowledged today that the maps before it are all within the realm of fairness and reasonableness, and so this is not a...
I'm sorry, I cut you off.
Yeah, go ahead. Yeah, sorry, Your Honor.
You had an expert at the hearing, correct?
So the Senate Republican interveners did not actually present tests. We had an expert submit a report which addressed the traditional districting criteria. The House Republican interveners put up an expert and conducted the examination and cross-examination of the experts at the hearing. We deferred in almost all respects to the House to conduct that aspect of the hearing since we were aligned with them and they had retained that expert and sponsored that expert.
Counsel,
yes.
question. You're representing a political body. This court tries to stay away from politics. As we repeatedly say, we're forced into this. We're now faced with the development of some type of standard to consider a plethora of maps for which all stipulate are constitutional. What do you share with us should be our priority in establishing this new standard, if it met the base? It appears from the numerous arguments that it's partisan considerations. What would be the most judicially neutral partisan consideration which would separate your plan from all the others or vice versa?
Well, I think at the outset, Justice Doherty, one thing, of course, would be the neutral criteria. You start there. And I wouldn't concede that every single plan has met all those criteria. We've heard that some plans split subdivisions when it wasn't necessary to do so, and we've heard that some plans do not maintain perfect population equality as between districts. So that's sort of the threshold proposition. I'm here today to unabashedly advocate for that the deciding criteria or the factor that can be the decisive one in this case is the process for HB 2146. It went through a transparent, open, deliberative public process, received 399 comments, was adjusted in light of those comments, and
Is
was
that your best argument?
well, it's the argument that I think is the way that the court avoids the partisan morass that it's discussing, that you're referring to, Your Honor.
So if this court were to accept it, and candidly, if this court were to accept it, then what we have now stated to the Pennsylvania, the world, is that in order for a map to be considered, and there are two opposing parties, you have the executive, a different party than the legislators, that if the legislators hold quote-unquote public hearings and seek no presentation in violation of the Constitution of the governor or a veto from the governor, that it will fall upon the court, as Justice Brobson keeps mentioning, and then ultimately whoever has the public hearing wins until we have both parties having public hearings excluding the other and no process. If we're to be transparent and we want to show the world that if the court has to make a decision which is inherently political, what is the most judicially neutral way of going about that? We've met the criteria. No, there is before this court no challenge that any of these maps do not meet the groundwork of League of Women Voters. Now we're looking at partisanship, and there's a plethora of considerations. Is there a paramount one, or what is it? The politics is for you. You're the good guy on that one.
Right.
We're not.
Your Honor, I have 2 points to make in that, but I'll answer the question I know you're driving at first, which is I think that you have to respect Pennsylvania's natural political geography, and that's come up throughout the testimony or the arguments today. If you use another metric of any sort to try to adjust or control, and you're hearing the buzzwords create competitiveness, create partisan equality, create proportionality, what that really means you're doing is boosting one political party, the Democratic Party, in light of the results or the electoral prospects that they might otherwise have under the natural political geography of the Commonwealth of Pennsylvania, which, by the way, every party, as far as I know, to this proceeding, agrees does have a tilt in favor of the Republican Party. So what you're doing is exactly that. It is partisanship because you're boosting the electoral prospects of one party.
I just have to take some offense. And again, I'm not a politician. I've been a judge for 30-some years. I read Judge McCullough's opus in its entirety, and I don't mean that pejoratively. She did a very fine job. And I appreciate, I know well Pennsylvania, having driven from Pittsburgh to Philadelphia 60 times in the last 30 years, the geographic disparity. On the other hand, Pennsylvania between 2010 and 2012 held I think this is correct, 18 statewide races. Democrats won 14 and lost 4, or won 13 and lost 5. And on average get about 52.5% of the vote. I don't think either makes any difference. I don't think we're lifting up or knocking down anybody. We look at the 4 natural constitutional criteria, which we can all recite and we'll have nightmares about. Then we look at partisan fairness. And that doesn't mean you lift up or knock down anybody. Just make sure that it's not somebody's been tricked into something that's not fair. And I think what Justice Dougherty said to you, and I think it's probably right, is we don't care about the fact that Democrats carry 52.5% of the vote. We don't care about the fact that the Democrats are packed in the 2 corners and the T's all Republican. We care about the 4 criteria, then we care about partisan fairness, and then what he said to you is what distinguishes your map after that's all done, because you passed that. And I think your answer was the process.
The process is a big part of it, Your Honor, and I was trying to get to the partisan question as well, but I do that. And again, the unique circumstances here where
I agree yours is not partisan biased. It's partisan fair. Is that right?
I think it's partisan reflective of the geography of the Commonwealth of Pennsylvania, and therefore it is fair. Yeah.
Let me ask you one last question. Just I wasn't even going to, but I got you here. If we're looking at process
Yes.
as a distinguishing factor, then would you put up with your map the Gressman map, which was all the scientists who got together, and whichever map was provided by the committee of 70 with the 77,000 maps, both the superior processes? And would you view them as having a leg up on everything else?
I think the Gressman map is a little different because it was created by a supercomputer, as I understand it, and not a human being. And I'm not sure that it was opened up to sort of a public input process as much as it was created with very precise scientific computer-generated metrics. The other map is, yeah.
I have to just interrupt you.
That's fine.
There was a computer, obviously, at the center of it, but there is also a group of distinguished professors,
Sure.
mathematicians, data experts, scientists who were involved in the process.
And-
I don't want people to think there's a room somewhere with a computer that did this. A group of academics did it.
And I didn't mean to denigrate them whatsoever. My point being that, you know, as far as having an actual process where members of the public had chipped in and participated and provided feedback, I am not sure that there's any evidence of record that that happened with that particular map. The other one is more, you know, has more of a public.
Draw the lines that.
I think that's right. It had more public feedback and public input, right? You know, as far as I understand it, I don't know all the details of how that was created, or even if there's a record of that, for that matter.
Would you give it a leg up because of that?
I think that it gets a leg up because of that. I mean,
Fair
if you want to acknowledge that this is a public process and the Constitution envisions that it be a public process as opposed to a map created by one person or one computer or a person working with a computer, then the public input is important. So thank you for your consideration. Yep.
No further questions. Thank you very much.
Thank you, Your Honors.
Thank you.
Representative Cutler, represented by Mr. Tucker. Or Speaker Cutler, is that accurate? Yes, sir. Yeah, the Speaker of the House. Excuse me, I apologize. Met him, know him, and like him.
Good afternoon, Mr. Chief Justice and Your Honors. May it please the Court. I want to introduce my colleague, Patrick Lewis, who, you know, although I'm the one up here arguing, we're very much a team and very appreciative of all his efforts in working as much on this as I have.
Pardon me, what was your colleague's name?
Patrick Lewis. And my name is Robert Tucker, and I represent Speaker Cutler and Leader Bettinghoff. I want to start by saying that, you know, my client, at least the Republican caucus of the House that I could speak for, did everything they could to try to not be here today. We recognize that this. Right. We recognize that this court does not want to be put in this position. This court does not want to have to be the one to make these types of political decisions. And that's why, in going through the process of enacting HB 2146, it did everything they could to try to follow this court's guidance in LWV. It drew a map that complies with the traditional redistricting criteria. It drew a map that, from numerous partisan fairness metrics, is fair. But unfortunately, the governor, by his constitutional right to veto the map, vetoed it. And so, unfortunately, you know, the situation is now left in this court's hands to figure out what to do. And unfortunately, this court doesn't have a framework for this situation. What do we do in an impasse case just like this? And I think what we've heard today is everyone seems to agree, well, the floor starts with the traditional redistricting criteria and making sure a map meets those basic traditional redistricting criteria. And I agree with Mr. Holtzman. I don't think that all those maps do meet that criteria, and I think that is one easy way of eliminating some of the maps. But there probably will be, Your Honors, some of the maps that you will find after going through all of the evidence in the hearing today that maybe do meet that basic floor. And the question becomes, what then? What do we do? And I believe what we've heard a lot is we have to turn to partisan fairness. And I'm not so sure that we necessarily agree that is the first approach. I think, similar to what Mr. Holtzman said, we need to think about what process we want to have. And I do agree with Mr. Holtzman that having a public process and having a map that comes out of a public process is very, very important.
Well, wait a minute. I thought you were starting to give us a refreshing perspective that your plan should rise or fall on its merits, but you are now reverting to the argument from authority, which I guess is channeling Judge McCullough's words, urging us to recognize and revere the express will of the people is a quasi-religious language. How is the will of the people engaged in a half process? As Justice Brobson mentioned, I'm just a bill. So if the statewide elected executive vetoes it, it's just a bill. So are you prepared to convince us on the merits of your plan, or do you rely on the argument from authority?
And I'm glad you asked that question, Justice Weck, because I want to clarify something. There's been a lot of talk about Judge McCullough's report and recommendation about giving the plan deference. That's actually not what she says. On page 208 of the opinion, she expressly says that she declined to do that summarily, and instead assessed HB 2146 evenly and through the same rigorous scrutiny against all the traditional constitutional criteria and measures on the same plane and footing as the other parties and amici and respective maps. That's on page 208 of her report.
Her conclusion is definitely talking about deference.
I think what she's talking about, Justice Todd, is that I went through and analyzed all of the maps on equal footing to start with. And I actually found that on the various metrics, HB 2146 does as good, if not better, than most of the plans. But it also had the added benefit of having gone through this public process. And it is the closest. It perhaps doesn't have the effect of deference, of representing the will of the people, but it is the closest.
Suppose we choose not to revere any plan, and suppose we just choose to look at them on their merits or demerits, and choose to be rational rather than spiritual about this thing. Can you look at how you've drawn Philadelphia and explain to us why 4 members of Congress need to represent Philadelphia as opposed to 3 right now, and why you split, I think, 5 wards? What's the basis for that?
Your Honor, unfortunately, similar to Mr. Holtzman, I don't know whether that specifically is addressed in the legislative record. If it is, it would be in there. I can't specifically say, sitting here today, exactly why certain wards were split, other than, given Philadelphia's population, some splits have to be made in order to accommodate population equality. And the other thing is just that, again, during the record, there was no accusations or any issues raised with any of the splits made in HB 2146. So there's nothing in this court's record that takes any issue with the way that HB 2146 split any particular cities, towns, or municipalities.
But, you know, given the history of the United States, but in Pennsylvania in particular, we're very sensitive to the G word, gerrymander, and it's sort of, and I frankly in preparing had not caught that, but I'm glad my colleagues did. When you start splitting, dicing, and cutting Philadelphia, which is an 80-20 Democratic district, it looks like you may be engaged in a gerrymander, and I think it behooves you to tell us, well, perhaps you can't, but it behooves us to make sure that's not so before we adopt this map.
I think it does behoove this court to make sure that's not true. But, Your Honor, I mean, there was no evidence in the record before the Commonwealth Court of any of that. There's no record that any split was made for partisan gain.
Counsel, there is no evidence in the record that Pittsburgh was divided for political purposes, and yet Judge McCullough drew that conclusion. So I think all we're doing is sort of following through on this rationale that you look at something that might look unusual and ask the question as to why it looks unusual.
Actually, I think, Justice Donahue, there was some evidence in the record that Pittsburgh could be divided for partisan gain. First of all, Dr. Barber talked about that in his report, that by dividing the city of Pittsburgh, you were able to create 2 Democratic but still safe-leaning seats instead of just 1. And I think also Dr. Naughton talked about that a little bit as well.
Well, I think to be fair, I think what the record probably shows, and maybe Judge McCullough drew an inference, was that it wasn't necessary. The Constitution doesn't prohibit the splitting of Pittsburgh for political reasons. The Constitution prevents splitting the Pittsburgh unless it's necessary, or absolutely necessary, whatever the language is. So the answer to that question, I guess, might lie in the middle somewhere.
I think that's fair, Justice Brobson. I think what the inference is, there was no explanation for why the city of Pittsburgh was split in the record.
Mr. Tucker, while I have you, because I think Justice Wecht tried to get you there and you're not going, so I'm going to try to push you a little bit further. The expert reports I found relatively unhelpful because they all use different metrics, they use different elections. Some experts want to use these elections, other experts want to use those elections. And my experience is you hire the expert that you think is going to be beneficial to you and use the data that you think think should be used. I have taken a little bit of razzing for citing Dave's redistricting. I'm going to attribute that to being the new person on the block. But I tried to do what I think a normal human being would do and find, if I'm going to analyze all 13 plans, find some common factor where they use the same elections, good, bad, or indifferent, and go across the board and not really rely on anything but that. By doing that, I had to conclude that while the House bill may not be gerrymandered, while it may not be out of the realm of what Chief Justice Roberts calls gobbledygook, but the realm of efficiency gaps or mean medians, whatever is an acceptable number, would you agree with those who have suggested it is on the somewhat outside as compared to maps that are closer to neutral? Would you agree with that?
The way I would put it, Your Honor, is there are certainly maps that are closer to zero on certain of these metrics. But I don't necessarily agree that that means that the maps are less biased. I think it all depends on how you're defining bias and what you're comparing it to. And the example I want to give is going back to what this court, the type of expert evidence this court looked at in LWV, which is simulation analysis. That was the crux of the expert testimony this court relied upon in LWV, was looking at what do a bunch of maps that are drawn, unbiased, just on traditional redistricting criteria, what do those maps look like? And how does the map that you're comparing it to compare to those maps? And when you do that here with HB 2146, Dr. Barber showed that we have a map that sits right in the middle of the range of the distribution and is very consistent, actually, with those partisan fairness scores, the mean, median, the efficiency gap. What you see on the opposite side is that when you...
I'm sorry, Counsel, you caused me to pause. You keep referring to Dr. Barber's expert opinion as being essential to the decision of Judge McCullough, yet it's my understanding Dr. Barber used a sequential Monte Carlo analysis, which had been challenged by a Fry test, would probably have been denied because it's not even been peer reviewed. So how are we to give credence to the expert testimony of an individual or two individuals, one who has no scholarship in writing regarding this particular subject, and two, to another expert who used a analysis that's not even been subject by his peers?
Well, I would disagree respectfully, Your Honor, that Dr. Barber's testimony would be denied under a Fry analysis. I mean, I think the algorithm, even though it hasn't been peer reviewed, it's under peer review, it's been validated, and that very same algorithm has been used and relied upon in other cases, including in Ohio, and by this state's Legislative Reapportionment Commission. But even if you don't believe Dr. Barber, then take a look at the governor's own expert, Dr. Dilution. She conducted an ensemble of 100,000 maps and reached the very same conclusion. When you look at those maps, they all demonstrate a demonstrative tilt in favor of Republicans. And when you compare the governor's map to those maps, it's an outlier. She admitted that during the hearing.
Just to support Judge McCullough's opinion, if I'm not mistaken, in the fact I think she credited Dr. Dilution 36 times throughout her opinion, but she found the doctor not credible.
I think she found her credible in certain circumstances based on certain metrics and numbers, and not credible on others. I don't think she found Dr. Dilution entirely not credible.
As an old trial judge, that's a pretty sharp knife to use.
But I guess what I'm saying, Your Honors, is encouraging, if this court is going to look to partisan fairness as the tiebreaker, comparing those numbers to zero is not the correct approach. Because by comparing those numbers to zero, you're not taking into account the natural political geography of the state.
You're saying, yeah.
Can I stop you? That's just not accurate. That's not the outcome of the scientific analysis that is used in these circumstances. The mean median test takes into account political geography. That's the purpose of it.
That's not correct, Your Honor. The mean median is a raw score. It does not take into account the political geography. So if you have a mean median score of 2.3, that reflects there's a bias in the plan. It doesn't tell you anything about the source of the bias. That's why you have to compare it to a simulation analysis by drawing a bunch of maps, which is exactly the same methodology this court relied upon 4 years ago.
On that simulation analysis, let me ask you on your simulation analysis. He testified, Dr. Barber, that he instructed that model to not split any municipalities below the county level. And to make that possible, he had to allow a population deviation of 0.5%, meaning that'd be plus or minus about 3,800 people. So what's the utility of any results produced by a simulation under parameters like that? How is that useful at all?
Justice Weck, that's a common thing that happens with these experts in these simulation analysis. Dr. Pegden's analysis, who this court relied upon 4 years ago in LWV, had the exact same population deviation issue. He had a 1%, and even in some of his simulations, a 2% population deviation. But this court found that his opinions and his analysis and methodology were reliable because after you do that, you can make some small changes on the fringes of the districts that don't have a meaningful impact. That comes from Dr. Pegden, not even from Dr. Barber.
But why would you want to instruct, I mean, why would you want to instruct it that way? I mean, if it's possible to control for equal population without such a large deviation, why wouldn't you instruct it accordingly?
Because as Dr. Pegden talked about 4 years ago, it's difficult to get these simulation methodologies to work to that much of a mathematical equality, but you can do it and still draw reliable results from it. And again, I just want to emphasize that's the exact same methodology this court relied upon 4 years ago.
But we relied on it for a different reason, counsel. When the testimony was presented in 2018 before Justice Brobson, I mean, the simulation methodology was used to establish that the 2011 map was gerrymandered. It was not used to create a new map. I mean, it was a totally different reason for using the simulation methodology.
I fully agree with that, Your Honor, and that's why we're saying that I think trying to go to partisan fairness as a tiebreaker is difficult, because here, although we say that some of these maps are statistical outliers when you compare it to a simulation analysis, but if here we're saying all these maps are generally within the constitutional area of fair, then how do you determine what is the most fair?
Everybody's suggest is the easier method as opposed to the harder political fairness.
What I'm saying is there's really, in this circumstance, I see in LWV this court found a judicially manageable standard to identify a partisan gerrymander when you're looking at a particular map. But when you're looking at 13 different maps and you have all these different metrics and different ways of calculating these metrics, I mean, the outcome of a mean median score or an efficiency gap score depends on which elections you look at. There are so many things that go into this. There is no judicially manageable standard in determining what is the fairest map of those.
Mr. Tucker, I think the point is, I think if I understand the sense of your argument is, number one, it's hard for this court to evaluate what political fairness is. But your point would be political fairness isn't 50-50. It's not zero, because all of the experts said, drawing from 100,000 maps or 50,000 maps, just because of the geography, the congressional seats are not statewide elections, there's a plus something in favor of leaning Republican. We don't know what that plus is. There seemed to be no expert testimony on what that plus is. But your point is that plus, whatever that is where your zero should be. And anything to the right or the left would be partisan.
Correct. It's not driving the metrics to zero. It's driving the metrics to what do we get when we draw a bunch of neutral, unbiased maps just based on traditional redistricting criteria. Although I want to...
Justice Todd your time is drawing nigh, so Justice Todd has a question.
Thank you, Chief Justice. Mr. Tucker, in the proposed recommendation of findings of fact and conclusions of law by Judge McCullough, she makes the statement that the House bill map actually leans Democrat. Could you tell me, do you agree with that, and can you explain why that would be?
Yes. I mean, Dr. Barber's analysis reflected that when he used a set of elections, all statewide elections excluding actually the judicial races that one of the other experts used. Other than that, the same 17 set of elections from 2012 to 2020, and predicted that, overlaid that on HB 2146. He predicts 9 Democratic-leaning seats and 8 Republican-leaning seats, which is an important point. Now, we'll admit.
Why doesn't that make your map least desirable? Because it's not partisan fair.
I guess I disagree with that. And this is a point I think nobody's brought up today yet, Your Honors, is nobody's talked about Mello and how this court looked at partisan fairness in Mello. What the court did in Mello was that we were losing 2 congressional seats. And what was fair was to make sure the loss of those 2 seats was borne equally by the parties. So there we went, I think from a 23 map to a 21 map, and they bore the loss of those 2 seats equally. Here, you can't split a congressional seat. But we're going from a map that has been 9-9, the map this court adopted 4 years ago. It makes sense that this court, if we're looking at partisan fairness, should go to a map that's 9-8. And what we have, and what many of the other maps that have been proposed, and I think Justice Brobson was talking about this from some of Dave's redistricting, but you can also look at the report of Professor Rodin, the Carter petitioner's own expert. He predicts even the Carter petitioner's own map, a 10-7 map. In no way do we have a fair map when we're coming from 9-9 and going to a 10-7 map. So a 9-8 map is fair. And look, we'll concede. If you look at some different sets of elections, say from 2014 to 2020 or 2016 to 2020, HB 2146 may flip the other way and be 8 Democratic-leaning seats, 9 Republican-leaning seats. That just actually demonstrates it's fair. It actually reflects the fact that it's responsive to different electoral environments.
All right. Do you want to say anything in conclusion?
Yeah, just briefly to conclude, everyone, today has been arguing over what is the fairest map, and there's just no way to really predict that. I mean, I think some of the political scientists have used this analogy. There are more ways to draw districting maps in Pennsylvania than there are atoms in the universe. So it's impossible to figure out what is the fairest or the best map. But this court did assign a special master to review the evidence and make a recommendation. And Judge McCullough did just that. And in a very, very detailed 222-page report supported by the evidence, recommended that this court adopt HB 2146. And we've heard nothing today as to why that recommendation should not be adopted. And we believe it should be. Thank you, Your Honor.
Very much. And certainly not least, but last, the voters of the Commonwealth of PA, Ms. Gallagher. And I promise you we are still well awake and anxious to hear you.
May it please the court, I'm Kathleen Gallagher, and with me is my partner, Russ Giancola. I'm here representing a group of the people that this process is all about. Not about the legislature, not about the governor, not even respectfully about this court, except to the extent you have pointed that it has basically been thrust upon you. It is about the voter and one guiding principle of our Constitution. One person, one vote. All the rest of what we have discussed and have discussed in the 20-some years that I've been involved in redistricting litigation and the process is achieving that constitutional mandate. I have heard, and one of the benefits of being last is to gauge not only the court's interest in certain issues and the parties' responses, but in this instance, since the issuance of Justice Dougherty's concurrence and what I have heard from, we've heard from Justice Todd and Justice Donahue today, and even Chief Justice Baer, this is not a process which this court welcomes. This is not your normal job. It is something, we are here for one reason, and one reason only, political failure. The political part of the equation failed the voters of this Commonwealth. And as a result, it's now at your door, or on your bench. And that angst, certainly judicial angst that I believe I've heard today and in Justice Dougherty's concurrence, is well-founded. Because if we look back, we have to look no further than Justice Kennedy in Veith, where he talks about the balance that the courts must take when they're thrust into what is outside of the judicial process and clearly places you in the political process, the process where no court belongs. Right. And especially a process, as Justice Kennedy eloquently discussed, which often, meaning redistricting, leads to ill will and distrust. Because if the voters and the people of the Commonwealth must have trust anywhere, it must be in their courts. You have asked repeatedly today, how do we pick? How do we pick the winner and how do we pick the losers? If amongst equals, correct.
So what's your
Given the
recommendation?
time frame, given the time frame, because if we had all the time in the world, we would be like a trial judge sending the jury back in to deliberate more. We would tell the legislature and the governor to sit down together and give them a dynamite charge and you know,
And don't come
get it
back till it's done.
Don't come back till it's done.
Right.
We don't have that luxury.
But I think you take your own advice respectfully, because I have the unique position of being here today as an advocate for my client's plan, but also as one of the amici. And never have I taken more seriously or literally being a friend of a court, which I've had the privilege of serving for more years than I want to say on a public record at this point. Okay. If I could act only and give me that latitude for these a few moments, what do? You take your own advice and you look at what you did in LWV and you pick the map that sticks. Because Chief Justice Behr now, one of the things that I found is equally compelling as I studied the LWV opinion was your dissent, sir. And your dissent in the sense where you say, I am not interested or I'm disinclined, I apologize if I misquoted, in injecting into the free and equal elections clause anything that's not specifically there. And your concern, sir, about transparency in the process. In our brief, we have said we support the adoption or approval of HB 2146 because it came through a process. And where we will differ from my people who went before us, that process was this court's approved process in the appointment of a special master to make recommendations to you. And I would submit to the court, what do you do now? You take what you did in LWV and you take that floor, and if the map which was suggested or recommended by the special master meets that floor, you have met your own standard.
Okay, let me ask you about that map. I asked the Republican Leaders Council the question I'll ask you. Are
Sure.
you prepared to defend or support the map for districts 5, 3, and 2? And I guess that's another piece of the Montgomery seat. Is that 4, whatever that is, 4 different congresspersons for the city of Philadelphia? Because you've urged us to accept HB 2146, which Judge McCullough told us to respect and revere. So I'd like to know why we should choose this map in conjunction with the fact that it splits, I think, at least 5 Philadelphia wards and puts 4 Congress members there.
So just if I may clarify, what I've suggested was if you follow the process and that process, you find the map that was selected meets that criteria, then it should be selected. I am also here to advocate for the map of my own clients, all right? A map which was vetted, although we were not present during the course of the hearing, which Dr. Dilution rated as one of the first-tier maps. The maps presented by the voters of the Commonwealth of Pennsylvania is the most compact. It splits, I believe, the least counties. I have to put my glasses back on, excuse me. It is the only map which has no 3-way splits of any county. Our map split in its municipal splits. It does not split the city of Pittsburgh. It is most critical item that we have is the lowest segments and pieces of any county splits.
But it has 79 total splits, which is the most of any, or at least among the highest of any.
Justice Todd, I believe where that comes from is in ward splits, all right? And those ward splits were done and in addition to comply with the absolutely necessary criteria of not splitting political subdivisions, all right? That's the reason for the ward splits.
Like, if I'm, Counselor, the way I thought I broke this down was you split 15 counties, which is in the middle, 13 being the lowest. You split municipalities 18 times, and municipality segments 37 times, and you split 41 wards. 41 wards being outrageously high. Next highest would have been the Ali map with 33. So share with me, why did you concentrate on splitting wards more than anything, taking into consideration community of interest, because that's really what a ward is in Philadelphia, let's say.
Understood, Justice Dougherty. But to concentrate on what we've heard a lot about today is the political influence of a larger municipality of a ward. Respect for the wards, but the need to achieve the compactness score, all right, something has to give sometimes, and to achieve those scores, the wards were split in order to allow the larger political subdivisions to remain intact.
The wards in Philadelphia have to get split and not, say, Erie.
I apologize if I cannot answer that question, but all I know is the wards were split pretty much equally and as necessary. We do not split. We do not have splits upon splits. And less than 25% of the population of the Commonwealth is impacted by our splits, where it is much higher in many other of the maps. Sure.
What do you recommend as the manageable judicial standard that we accept when we have all maps on an equal playing field? That, the equal playing field being meeting the criteria of the foundation, the base of our legal women voters.
And that's why maybe I was taking the easier way out when I said to the extent you have appointed a special master to the point of transparency, correct? You set this process up. If that map, which is recommended by that master, meets that criteria, it's deference to the process the court has instituted, right? As for the making of those recommendations.
If the court doesn't accept that recommendation, what would be the next manageable judicial standard from your perspective and your client's perspective? As friends of the court.
As friends of the court, follow your own advice and do what you did in LWV, which is to draw a map which only complied with my understanding, and again, I could have read it wrong, which only dealt with that floor criteria, right? The future questions were, you know, any other considerations were to go to the future. You use partisan fairness, and that word has been so perhaps
Mr.
over.
Gallagher, the problem with that is we have 13 maps that, I may disagree that all of them comply, but let's say 9 of the 13 comply with the floor. And you're saying, even if you don't give deference to what Judge McCullough did, just follow the floor. We're still left with 11 maps.
They're not identical.
How do we pick, well, that's, I think, Justice Dougherty's point, is we can't use that because at least 9 or 10 of the 13 already comply with the floor. Where do we go beyond the floor to pick among the 9 or 10 that comply with it?
As a friend of the court, I would go back to what Justice Dougherty just said, and you expressed a concern about our map, all right? You expressed a concern that perhaps it's split wards that should not have been split. If there are 3 maps like that, which are not splitting wards, but would appear on its face to meet that neutral criteria, at least meet the floor, as you delve deeper into it, there may be parts of that criteria, the way in which it is dealt with, that is not acceptable to the court. In Holt 1, there is discussion and guidance about which splits take preference, all right? Which splits mean more. So where a map could have an equal number of splits Justice Robson, I don't know if this is answering the question. Not all splits are equal.
Well, I think you are answering the question. It's an
Okay.
interesting answer. I think the answer, if I'm understanding what you're saying, is don't go down the partisan fairness road. Examine each map to see how they comply with the neutral criteria and pick which one you think best deals with the neutral criteria as opposed to going to partisan fairness. Is that your point?
If the court, yes, I do. And I,
Ms. Gallagher, thank you. You're in a very interesting advocacy position. If I understand, and I'm trying to listen hard, you advocate for 2146, which is Judge McCullough's suggested map. You argue in the alternative for a map that you drew,
correct.
which you say is good, but not as good as 2146, or perhaps is as good, but should not be chosen because 2146 should be chosen because of deference. Now,
No, sir.
I'm just trying to first understand these two maps and where you are as an advocate.
I am in the first instance a student of the law and the process. It is the process which surpasses all of us, correct? These maps will come and go. As Justice Wecht has pointed out, the 2018 map was overruled, was found to be unconstitutional in 2018, and the new map was brought in.
Right, the 2018 map was good.
Correct. No,
You're not
in
answering-
2018, the map was
My question is not esoteric or philosophic. Are you for 2146? Are you for your map? Are you for something else?
I am for our map, all right?
Okay.
We believe that our map is, even under Professor Dr. Dilution, highly acceptable. However, the process which the court has set is that of a special master, all right? And we would give deference to that process if the court finds it meets that criteria.
We don't defer to a special master, though. We assign something to a special master to give us proposed findings of fact and conclusions of law, so her report, while thoughtful and, completely exhaustive in her work, it's a recommendation to us.
Understood. No, I said I would defer to that process if the court found that it met the appropriate criteria.
So first yours, second hers, and then, again, if I understand your dialogue with Justice Robson, almost do an objective analysis of which, if we respectfully reject 2146 in yours, which of the other maps does the least offense to the constitutional criteria of compactness, contiguousness, not splitting of lines. Is that where?
After HB 21, Reschenthaler 1 and 2, and draw the lines.
Okay, thank you. I think that does help me. I'm sorry. Justice Doherty? Anybody else? I want to thank everybody here or listening. It's been very difficult, and I really think we've had superb advocacy by everybody, top to bottom. A lot of effort put into this. It's an important question, and now it's our turn to do the very best we can. Thank you all. Good day, though.